Yes, yes.
My lord, they are taking time, my lord. I have no objection, but I'm paying for a fixed date, my lord.
46.
51, my lord. I'm appearing on 46 and 48.
What about the other count?
I have informed Lordship.
46 to 51. Then deferred to be listed in the month of July on a date fixed by the registry. On the request made by Mr.
But may I pray for a fixed date, my lord? May I pray for a fixed date, my lord?
Fixed date to be given by the registry. They'll give a date.
Obla Lodge.
I beg to mention item number 45 and for a petition I have taken consent from the other side. So, today my
45 with the request of the council for the it is listed up. It's submitted consent of the council. Okay.
Hello.
Yes.
May please, Lordship, item number 15. Kindly adjourn this matter, Lordship, and fix it on Friday.
Your board,
Petitioner, Lordship.
item 16, your name,
D. Kolita.
the D. Kodita, council. The matter be deferred. Prayer not taken by the respondent.
Please, Your Lordship, with the consent of other side, I beg to mention item number 10.
Yes.
Conducting council party is out of station.
Item 10. Yeah, take up.
Please. The concern of the other side, I beg to mention item 59, my lord, on behalf of D. Purcaster, my lord. Let this matter be passed over for the day, my lord.
Item 59.
Yes, my lord.
Yeah.
May your lordship please, I would like to mention item number 40. It may be adjourned for the day as my senior is not keeping well, having high fever.
Item number
40. 40. 40.
I beg to mention item number 11 and 21. I am appearing on behalf of the senior sales Bora. She is not well, so item may come up 2 weeks.
11 and 20.
Yes.
Please, Your Lordship. Lordship, they had not complied with the order dated 24/9/2024.
They have complied.
They had not complied with the order dated 24/9/2024. Yeah.
The order dated 27/1/2025 has been violated by the respondent authority. Lordship will find at page 20 of party part ballot at page 23. Oblige.
Lordship, in this matter, by the order dated 10/4/2025, Honorable Court directed for reinstatement of my service. As of date, they have not done so, Your Lordship. Lordship, may I pray, if the Lordship permits, I'll take dusty service. The person is
Dusty.
retiring, man. With your permission.
Matt is good. Lordship is application for correction of date of birth. Lordship, I am an executive engineer in the service since 1992. And my date of birth was recorded as
20/09/19 sorry, Lord, 31/09/1965 instead of 22/09/1969. On the last occasion, Lordship, the respondent was asked that they claimed that if my date of birth is 1969, then I will be underage. So, Lordship, if it is 1969, then my matriculation year is 15 years, and service I have joined at the age of 23. And if it is 1965, then my matriculation is 19 years. So it's totally unbelievable, Lordship. And I approached the concerned authority to correct my date of birth in the year 1984. Till 1984, I have been waiting, and I went to the office. They just assured me that your date of birth will be corrected. But Lordship, kindly look into the date 31/09. This is September. September consists of 30 days. They have written 31, Lordship. They just correct it and give me the certificate, Lordship. I am on superannuation in the year this year, September, Lordship.
Who corrected the certificate?
The SEBA,
Where is the certificate?
NXR 2, Lordship.
Page number
Page
12.
page number 12.
According to you, your date of birth is
69. 22/09/69.
yes.
Yes, my lord. My lord, first of all, my lord, the board is nomenclature of the SEBA has been changed, my lord. Now it is known as Assam State School Education Board, my lord. And my lord, secondly, my lord, the board record the date of birth, my lord, as per particulars of statement provided by the headmaster at the time of appearing in the HLC examination. At that time, my lord, the headmaster provided his date of birth as 31/9/65, but before issuing of this certificate, my lord, it is observed that, my lord, there are only 30 days in September month. So it was corrected, my lord, on 8/6/1995. And my lord, see the prayer portion also, my lord.
No. When was it corrected?
My lord, here signature of the secretary here.
Why is it
reflected.
corrected in 95?
Lord, when it is seen that, my lord, that in recording date, my lord, in the month of September, it is wrong.
What
So,
is
my
the-
lord,
What is the date on the bottom of the certificate of the left hand corner?
yes, my lord, 8/6/95.
Left hand corner, bottom.
Yes, my lord, the 3rd of August 1984.
What is this date?
My lord, I will take the instruction, my lord, what actually happened, my lord. But I have seen that It
If
was-
you have no instructions, why are you submitting? The order, last order reflects that you had questioned the validity of the certificate.
yes, my lord,
Without instructions, why are you making the submission? The date on the left side bottom
yes, my lord,
is the date of issuance of the certificate.
yes, my lord.
So the certificate was issued on 3rd August 1984,
Yes.
reflecting the date as 31/9/65.
Yes.
Now on 95, why did you correct the date? Where was the occasion to correct it? Unless there is an application for correction.
Yes, my lord. And application, my lord, they are not shown any application, my lord.
You get your instructions
Yes,
from the
ma'am.
board.
Yes.
When are you retiring?
September 2025.
Third Council for Part. Mr.
DK
D.K.
Roy.
Roy, Planning Council, SEPA. Submits that the SEPA has been re-nomenclatured as what?
Assam State School Education Board.
Some state school education report. Therefore, the respondent stands corrected as, who is the officer here? Secretary.
Yes, my lord, secretary.
Secretary, Assam State Board, Assam State
Education Board.
Education Board,
Assam State School Education. Board.
Assam State Education Board, Government of Assam, Public Weather. Instead of Secretary, the Board of Secretary. The respondent will be reflected. The particulars of the respondent according to the corrected counsel will line up in within 1 week. Whereas Mr. Roy represents the council and therefore is the way now but take the required instructions and find necessary action. It's after return.
Date may be.
You first correct it. You have corrected the respondent, you file amended post title, then make a mention.
My lord, and my lord, in the prayer portion also, my lord, kindly see, my lord. Here, my lord, why the relief sought by the petitioner to issue a writ in the nature of mandamus surgery or any other like nature or the direction should not be issued to correct the date of birth of the petitioner as per the horoscope, my lord, as 22/9/1965 instead of 31/9/1969. Date even also wrong, my lord. Prayer portion.
It would have
You
been
correct it. So take it.
definitely.
May I speak, Your Lordship? My lord, in this case, my lord, other side has filed also, my lord, file affidavit. My lord, it's a covered case, my lord. The fact, my lord, the issue involved in the case is that, my lord, that the petitioner has been suspended, my lord, and his suspension order was not reviewed within the tenure of, my lord, 90 days, as per the mandate of the, my lord, the Ajoy Chaudhary and Deepak Malik case.
They have issued they have started disciplinary proceeding
My lord,
within 90 days.
no, my lord.
That
Inquiry committee has, my lord, inquiry, my lord, that as part of Ajay Kumar suspension, my lord, delinquent suspension cannot be, my lord, that, my lord, for indefinite period, my lord, extending by, my lord, periodic order. My lord, Lordship may kindly turn the page 79.
when were you placed in suspended?
Suspension, my lord, will file on page 39, my lord.
Give us the date.
My lord, 14/10/2024. Thereafter, my lord will file the extension order on, my lord, page 79. Page 79, my lord. Page 79 on the last paragraph from bottom, my lord. You can laugh at it. Therefore, considering smooth completion of the departmental proceeding, undersigned extended the suspension period of Rohim Ali Adale until further order with effect from 9/1/2024. That order has been passed, my lord, on 22/1/2025. And 90 days expired, my lord, on 14/1/2020. Thereafter, Lordship may kindly tell, my lord, that inquiry committee has only been, my lord, constituted in pursuance to the order, my lord, that is, my lord will file.
Notice not issued here.
My lord, notice issued, my lord.
It's issued.
Notice issued. Apart this, my lord, issues are very simple, my lord, the following the principles laid down in
Notice has not been issued in the matter. It has come for motion.
Lordship.
It's a not-
Notice, Lordship, 5/4/2025 notice was issued, most
notice issued.
5/4.
We have already
2025.
steps taken. Steps are also taken.
5/4.
Yes, Lordship.
This is item number 5.
25. 25/4, sorry.
Board. 25.
We have, we have also taken.
Report.
Yes.
But you have a copy of that.
Not with me. Who's letter?
Do you have a copy of that order?
My lord, the copy I haven't done for.
Not yet.
Hello. No. Dictate.
Anyway, we are issuing notice. at this
Lordship.
heard by the council. For the meantime, I put right there and out there. I have it.
My lord, can it be on, my lord, after 2 weeks? The other side has already filed their affidavit, my lord.
Can it be
My lord, after 2 weeks. My lord.
after
2 weeks.
2 weeks?
Some short date, my lord. Because my lord, other side has already filed their affidavit, my lord.
Wait, keep it on.
6 days.
17th
17/6.
or
I am appearing for response number 4 and 5.
or that's my bad.
My lord, they are already DLR has filed their affidavit. If my friend wants to,
So that's what we are keeping it for admission.
Yes.
Matter with Papa.
Yes.
But I am not. It's
For admission, my
Lordship.
not.
all these 4 cases are regarding non-payment of gratuity. It a developer corporation. Petitioner has retired from service in 31/3/2023 after getting it age of superannuation. Lordship will find
So we'll issue notice today.
in this particular case, Lordship
We'll issue notice today.
in this particular case on last occasion, Lordship was required to dispose this petition only directed to give effective instruction because gratuity is payable within 30 days from the date of retirement from service. No DP was issued against the petitioner. Petitioner has been given a clean hand and they have been released from service with everything. Now, Lordship, petitioner is receiving salary of a pension of rupees around 2,911, 48 rupees. So, how petitioner will survive? 2023 petitioner
When did you superannuate?
on 31/3/2023. It is payable within 30 days. And penalty is there. 30 days is not paid 10% interest as per notification of the government of India.
There is an appropriate authority. You can file an application there that
In this particular case, gratuity has been deposited before the Life Insurance Corporation of India. A Life Insurance Corporation has released the amount in favor of them, but they have withheld this amount without any authority.
Regarding that part, I don't have any instruction, Lordship. Only regarding this, I have the instruction, Lordship. Lordship may issue notice and I will file affidavit.
Because Lordship, if it is being noticed, it will delay the matter. Already Lordship has issued
Lordship,
the
I will
notice.
file
Okay,
affidavit.
when you come to court, there has to be some amount of time given to parties to decide a matter finally.
I understand, Lordship. I understand. Only thing is,
They have waited for
Whatever time it takes, it takes. Beyond that, if we want to hurry and pass an order, we may not be able to pass an order which be effective to ameliorate your grievance. So,
only for our side, Lordship. Only affidavit may be allowed to file, Lordship. Lordship may decide the matter.
this is not sufficient. You have
Yes,
to get more.
I agree,
instructions
Lordship.
on
I
this.
agree, Lordship. That
that I will file a parawise comment and if lordship.
The managing director has to take a decision. His apprehension that if we release, something will happen, it's not a ground to
Lord.
withhold the dues,
Lordship,
rightful dues of the
lordship
petition.
may pass an order, lordship, I will file affidavit immediately, lordship. We will
Yeah,
not take.
we'll issue notice at this stage.
Pray, Lordship. It's 50% will be released. Because money
Since 23, they are waiting, lordship, only 10 days time.
50% of the area salary is 58, Lordship. Area salary also not paid.
You have come before the court in 25.
25
When you
after
have,
repeated,
when you have superannuated in 23.
I have filed retention one after another.
Correct, but 2 years have already passed since your superannuation. Why can't you wait for another 2-3 weeks?
Lordship, I will wait. I have no objection to
So
that.
let us see what instructions come. Let us find out
I am
why.
making this submission on the basis of the on last occasion court has actually.
No, I understand that, but for 2 years you have waited filing representation. Then you come before the court, and now you can't wait for 2 weeks.
No, I can wait. Lordship. I can wait.
So let us find out what is there. Why are they withholding? You can show in the instructions if you want. Let us get the details of why they are withholding, what powers they have got.
As per section 7(3) of the Gratuity Act, gratuity can be withheld only on the ground that petitioner has been dismissed from service and departmental proceeding has been initiated against them before retirement. In this particular case, admittedly, there was no departmental proceeding. Petitioner has retired from service with honor.
I think of the other company. Standing of the AFP. Sir, what is the pay?
For one,
Number 3.
but sir, I'm appearing for fishery department also. You are appearing also.
Which AFDC.
AFDC and fishery department both, lord.
1,
150. In finance, here, lord.
1, 3, 4, 5. With the respondent representative. Council representative. Pre-voting. More particularly, part 3. They reprise the court. Right? The gratuity claimed by the Commission have been detailed for the past year. Let this instruct placed to the court and why no as with instructed with the court as why orders should not by the court directly claimed by the Please. Twenty
For admission hearing.
for it.
I file affidavit also, lord.
Whatever you want.
Oblige.
You furnish extra copies.
Yes, sir.
Immediate.
Already given. Lord.
Oblige, lord.
Yeah, the lordship. The particular it is petition matter regarding for back wages and monthly pension, my lord, and other service benefits, my. The other respondents,
We are issuing notice that
my lord,
anyone for the respondent.
Respondent Union of India is here and the Assam Gramin Vikas Bank, but they have not received the notice, my lord. Notice may go, my lord.
MSB Sharma for respondent number 1. Union of India, Department of Labor. Steps of the other respondent by registered state. As well as the courts within 1 week. This respondent was represented. Okay.
During the pendency, my lord, the authority may release the, my lord,
Tendency of the writ
provisional pension.
shall not be a bar or the prayer.
My lord. Highly obliged.
passed over.
Please, your lordship. Lordship, petitioner for your lordship has joined in the service under the assistant superintendent of police in Mulberry in the year 1987. He was rendering his service, lordship, on 17/5/2012, lordship, one SR was filed against him by the police authority itself, lordship. Subsequently, the disciplinary procedure was drawn and he was removed from service. Later on, lordship, the planet court below has given him the equitable, lordship. Against that equitable order, the respondent has filed an appeal, and that appeal also got dismissed. And subsequently, lordship, the petitioner has submitted his applications, lordship, to allow him to rejoin in service, and also submitted an application before the Director General of Police on 29/5/2019, lordship.
So he was what, dismissed from service?
Sorry, lordship.
He was dismissed from service.
Yes, lord. He was dismissed from service, lordship.
You have filed an appeal.
Lordship, as per my instruction, lordship, he has filed an appeal, lordship. And but subsequently, lordship, he have also submitted applications and also submitted RT applications, lordship, where the respondent has the director, Inspector General of Police, lordship, has sought in report from the SP Nalbari whether an appeal is filed or not, and some clarifications has also been sought, which was not. The SP also sent the clarifications, but till now, lordship, the representants or appeal has not been disposed of.
Appeal is pending. Appeal is pending.
Appeal is pending. To my limited knowledge, as per
Yes, Mr. Bora, please get instructed.
Yes, Lordship,
What
page
is the status of the appeal?
page 39, Annexure 11. The SP, Assam Police Headquarters, in fact, wrote to the SP Nalbari, wherein they actually sought clarification regarding what happened to the department proceeding drawn up against the petitioner, as well as secondly, they also asked whether the appeal has been filed by the petitioner or not.
That we have seen. You get the instruction.
Yes, Your Lordship, have to get it.
For one thing. Enabling the respondent. The appeal preferred by
Right.
the petition against the order. It is see that I get which the particular game not yet been furnished by HP. But it is kind of being taken up 1 week
11,
or a week and a copy of the working date to enable him to pay the department.
11th of June, Your Lord.
obliged.
Obliged.
May I please? Is the case pensional benefit, your lord? If I am getting the provisional pension, I have retired in October 2019, and pensionary, my pensionary paper has been returned by AG, the respondent number 6, for technical ground, and after that, our department has already submitted.
You
The
are
press-
serving under which department?
BSF.
BSF.
Your lordship,
BSF.
on page 18, your lordship. Return of pension case, your lordship. Because of the salary has been stepped up on the basis of my junior salary without obtaining any sanction. From the finance record. It was written on 8 August 2020.
Get instructed.
Lordship.
That's all. Bring it up. Which it continues. Take up time. Right. You're not getting provisional or
Provisional, I'm getting provision.
petitioner. And then what?
1, 3, 1, and then lordship 3, 2, 8.
Wait. And maybe for
Nine.
and then why have you added state of Assam if you are in the BSF? Political head, political director general.
Yeah, only the all state of Assam is part.
So, but he says he was employed under BSF.
Retirement level.
In the finance department, where sanction is required here. Sanction is required.
Returnable extra copy. Yes.
My lord, against imposition of penalty of demotion in rank, and also, my lord, the withdrawal of pension, my lord, by Assam Fishery Development Corporation. Kindly, page number 81, my lord, last page, may kindly. Last page, penultimate paragraph. Paragraph 82. And therefore, in pursuance of 7.3 and 4 of Assam Service Discipline Appeal Rule 64, read with Article 311 of the Constitution of India, I, such and such, do hereby impose penalty of demotion to lower post of assistant engineer, from which he was promoted to the present post of assistant engineer, FCDL, AFDCL, as well as withdrawal of retirement benefit, my lord. Now, my lord, there's a clear violation of the rules. And also, there's a lordship direct judgment. Can you withdraw? Can they withdraw, my lord, without following Rule 20 of the pension rules? The other day, lordship has passed judgment on that, my lord. Jayanto Monshinga case there. And number 2, please come to page number, my lord, 75. There's an inquiry report. Lordship would see, my lord, there's a mockery of following the rules of, my lord, disciplinary appeal rules. Please, 75, lordship is seen, my lord. Kindly see, middle, peruse the name of the documents. Lordship is seen. Kindly see serial number 6, DFI inquiry report 14/9/22. This part of inquiry report. Now, please come to page 31. Page 31, annexure 1. Please come to page 32 and then my lord, page 34 is the allegation.
Yes.
Lordship, kindly see, no list of witnesses, no list of documents, nothing has been mentioned. But land inquiry officer, what he has done, he has perused all these documents. These are not part of the record, my lord. So at this stage, my lord, I'll pay to your lordship to examine this matter, my lord. And so far, this judgment of your lordship, my lord, kindly have a look at this judgment 21. That your lordship is given. Just this one. My lord. 21. Or this one. My lord, lordship may kindly take this one. This is also lordship judgment regarding the rules. But kindly have a look first at this one, my lord. This one. This is also lordship judgment. Lordship is saying they must follow the rules. And here, total complete go by to rule 9 of disciplinary rules. This one, paragraph 19.
Paragraph?
Paragraph 19. Until unless an order is passed in terms of Rule 21 of pension rules, my lord, it is made clear that stoppage of pension of the petitioner or the action of the respondents in withholding the pension of the petitioner cannot be allowed to sustain. In view of discussions held above and in view of the fact that no specific order has been noticed from the records or from the pleadings issued by the department regarding stoppage or withdrawal of the pension of the petitioner, this court is of the considered view that prayer made in the writ petition ought to be allowed. That is what. Lordship, see page 81. Where from this came? In the charge of Shawkaz notice, there is no mention of withdrawal of the my lord pension.
Right.
So that part at least, my lord, I'll pay to lordship, my lord.
No, but unless we know what basis the pension was stopped, maybe the process had started for getting the sanction of the government.
But that has to be in the inquiry report and the my lord, the Shawkaz notice, my lord. Prima facie it is missing, my lord. Because of this, my lord, for a short period also,
Yes.
lordship may examine this matter. At this part, my lord, second part, that may be stayed, my lord. That notice. Let them come forward. If lordship find that there's nothing, lordship will packet this stay order.
There is an appellate provision is also there. Appellate provision, lordship.
All.
They can go for appeal, huh?
You're representing all.
Yes,
Yes,
for all.
I'm representing all, lord. In one case,
What is the date of the order?
My lord, order is 20, last page 82. Bottom, 82 bottom. 20 March 25.
Hereby, penalty of demotion were it is withdrawal of retirement benefit by from
Very severe. But
the time. When are you superannuated? You
now
retired.
I'm 57. Now I'm 57.
no, they are in service, lordship. They have not.
I'm not saying retiring. I'm 57.
Why your this retirement is stoppage of pension doesn't affect you as on date.
As on date, no.
No, that's true. But so far, my lord, out and out lordship is seen, my lord. Neither in the shock was my lord. At least my lord, lordship made an observation, my lord.
Okay, but
And it also doesn't affect them also, lordship stay
no,
also,
it
my
will not affect. But lordship, in another case, lordship have observed that they have to go for appeal, appellate provision. Another case, in a similar matter, lordship. They have an appellate authority, lordship.
Order. Where? Contract. The parent. The 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 20 About the other there is a secretary of appeal
Appeal lot.
before
Before the Secretary of the State Department.
the State Department. So appeal has been report.
They don't even service rules, my lord, don't even know who is the authority.
So it is a,
Therefore,
it is in the article of incorporation also there is there.
review of that
It is
subject that department
there. It is there.
protected level. It is not a it doesn't. See, it doesn't. What interim order you want?
Second part, my lord.
Which part?
Second, that withdrawal of retirement benefit for future also.
You're not retiring.
It's
My
3
lord,
years.
suppose the lordship pass this order also. It doesn't affect him also. Same.
So it doesn't affect him, but why are you praying for an order which doesn't affect
Why unnecessary? In the morning, I get up from the bed and I see there is my arrow is pointing towards me. Every morning.
you? You have 3 years to
In 3 years, I have to follow that arrow, my lord.
In
you have
2 weeks.
3 years to deflect that arrow.
That's what. Twice,
We are,
my
we are
lord.
issuing
Since on large on the face of the record, my lord, it's in legal order.
we are issuing a notice on the stay.
My lord, my
Let him get
my-
his
my-
instructions
my-
here.
my lord.
It's get on third of
Yeah, brother.
May I please, Lord? The petitioner retired on 31st January 2020 as a peon in the respondent company.
not received. So let us, why don't you get instructed first? It's not receive pension for what purpose?
My lord,
Get some instruction.
I am, my lord, one notice, my lord. Today I am appearing for respondent number 1, the enrollment. My lord, let them take steps, my lord. I will try to talk, my lord.
You're not representing the
This,
corporate.
my lord, I appear though, but once they get the notice, they send me the copy, my lord.
Yes, that's not number one.
One, my lord.
Yeah.
Me, okay,
Steps of the yes, both sides. This one. It's not returnable. Yes.
I have placed the order on an extra 6. He's very unfortunate candidate. He was crack all this examination, competitive combined examination has passed, and finally got selected. His ultimately, due to his physical disability certificate, his appointment was cancelled. He is 39. 39.
Diploma line senior start, my lord. Similar matter is fixed on 5th, my lord. That medical benchmark disability. The balance of verification is fixed on 5th of this. Similar matters.
Here I am appearing this board of with a copy of the it was also reflected.
You, what disability are you claiming?
We, at the time of examination, I have been 40% disability.
Locomotor.
Locomotor. Right.
You have less than 40%.
Initially, according to candidate, he was 40% at the time of examination.
In that certificate, it should.
Yes. There is issued by the Joint Director.
Now you appeared, and then there is a review medical board.
Review medical
and
board
they say that you are below 40%.
below 40%. But no examination was nothing sort was done.
When is it coming on 5th? You serve copies, we have this matter again on 5th. We'll list this matter again on 5th. Bora,
For 1 and 2, my lord.
very important. Deep.
Yes.
Oh.
Also WPC number 2301/2024.
WPC number
2301/2024.
that also he represents advanced copy the last picture advanced copy about the not the matter we take the again on if along with the
2301 2024.
you renew your prayer on this. We'll consider it.
If this one, there is a success ceremony of my family, Malad. Malad, that is most difficult for me, Malad. So can it be up?
Then have it on.
Well,
Do you want it next week?
Next week, Malad.
Or 9?
11 and 12, Malad.
All right, 11?
12, Malad. 12 Friday.
12 not 12 not Friday. 13 is the Friday.
June. 13 is a very expensive.
11. Also 13, I have some.
Your departmental counsel, you represent somebody. We are not even issuing notice at your submission. 13.
Hey, please, my lord. You're working as LDA cum typist, my lord, in the social welfare department. My lord, we seek minimum of the pay scale, my lord. My lord, our counterparts who are appointed in the same advertisement, my lord, our statistical assistants and supervisors, they have been enjoying the benefit of the state minimum of pay scale, my lord. Whereas we have been deprived. My lord,
for respondent,
social welfare department.
finance is also there.
Finance.
Yes.
Yes. You get instructed
Yes,
why
sir.
the minimum scale of pay is not instructed.
Lordship,
We were not inclined to issue notice. You get
Lordship.
instructed. But why have you not? Is there any circular notification?
No, my lord, but there is, my lord, may kindly have page, my lord. My lord, may kindly have page 42 for a moment.
Here.
My lord, the counterparts, my lord, that I was just referring to, my lord, the statistical assistants and the supervisors, my lord. If I may read my. Here it is said that they are to get the minimum pay scale. Since 21, they are enjoying this benefit. Like. Well, we had preferred a representation as well, my lord, before the respondent authorities, my lord. My lord would have that at page 46. Kindly. Director of Social Welfare, my lord. Prayer to allow drawing amount equivalent to regular of the pay scale.
Yes.
That, my lord, this has not been considered till date.
21 representative.
Yes.
So let them get instructed.
Yes. Yes.
Heard talking. So their contractual. What are you contractual?
My lord, contractual employee.
Working as
LDA cum typist.
LDA cum typist in the department of women and child.
My lord, women, we are working across various ICDS sectors.
Across various ICDS sectors. Believe that scale of pay and
Lordship, the order
Fine.
that they are relying on.
45. Method. 45.
Whatever now.
It was the finance department.
Oh, which is
Needed. Okay. It is. Yes.
Lordship, one thing he also need to obtain instruction whether their name was forwarded, Lordship, when the entire list was supplied to them. Lordship.
Department.
Separate. And forwarded.
Extra copy.
I'm deeply obliged, man.
May please, your lordship. Matter pertains to promotion of the petitioner, lordship. Actually, this case is second round of litigation, lordship. In the year 2022, we have filed a case for promotion, lordship. Actually, were posted as UDA, but we are entrusted the duties of higher cadet. That's why we came before the court and Honorable High Court, lordship, on the order dated 19/4/2022, Annexure 5, lordship. Page 41, lordship.
Yes.
Yes, lordship, that directed the petitioners to file a representation, individual representation before the commissioner.
You are serving as
We are now petitioner number 2 and 3 are now in charge deputy commissioner, and we are in petitioner 1 and 4 are entrusted to do assessment officer, but we are posted as UDA, lordship. At that time, we all were assessment officer. Now 2 and 3 is deputy commissioner, lordship. But still, we are getting the salary of UDA. But we are not going on that. We just need our second higher cadre promotion list. In then, lordship, poster vacant. Almost.
what happened after this order?
After this order, they have passed the reason order, lordship, and it's a 6, lordship. Page 43, lordship.
How many petitioners are here?
Now we are 4, lordship. One got promotion in the year 2023, lordship, and now 3. And I have annexed the gradation list also, lordship. We are in the seniority list in serial number 6, 8, 12, and 15. And as per the knowledge of the petitioner, there are 16 posts vacant of higher cadre, lordship. So we have filed representation also, lordship.
This 16 is over and above the 52. Page number 43, they show that there are 52 vacancies.
Yes, lordship. That will all filled up, lordship. In the earlier promotion that they have done, but we left out because of the vacancies all filled up, lordship.
So in page number 44, what are you? Where are your positions?
My gradation list is, lordship. This is my serial number 6 is the petitioner number 2. And petitioner number 1 is serial number 8, lordship.
Okay.
Petitioner number 3 is at serial number 12, lordship. And 15 is petitioner number 4.
What happened to serial 1, 2, 3, 4, 5?
They are not coming before the court, lordship.
No. Are they promoted or not? They are not promoted.
No. I don't know about them, Lordship. There might be
There
not
is service-
not be promoted.
No service rule.
No service rule. That's why they have said that they, in absence of service rule, they opted criteria, seniority as criteria for promotion, Lordship. And we are on the seniority list in within 16, Lordship.
Yes. Mr. Bora,
Well, let notice go my attitude. I have no. All the response.
that it is a prayer or something like that. It put it in but there the people yeah. Their date, their like the promotion next and get a department to think consider promotion the fill up books by name and the senior public by the department. And 7 we have so many seniority complaints criteria adopted by the Mora made of respect to the company.
Much obliged.
May please, sir. Petitioner before your lordship are CRPF personnel, sir. And they are stationed from 2019 to 2021 at 20 Battalion, my lord, Dipu Kargil. During that period, they have granted risk and hardship allowances, sir. But my lord, suddenly on 28/4/2025, they have issued a office memorandum that their recovery will be started, my lord. But my lord, similar case was pending, my lord. That is my case, my lord. Recovery was, my lord, state, my lord, in that.
Why recovery is made now?
Yes, my lord. Page 80, my lord. Kindly see, my lord. Impugn order.
80.
80. Respondents stated that they have given wrongly, my lord, risk and hardship allowances.
Yes, Mr. Mary.
Order is there.
Page 85, my lord. There is a similar petition, my lord. Some page 85, my lord. Relevant person is from 82nd.
All right, heard something.
Plus.
May I put your lordship, my lord, it is released from the petitioner's funds is
Yes.
Lordship, PISF Unit FPP Faraka is situated at Murshidabad district, Lordship, West Bengal, Lordship. And Faraka is the only station, Lordship, that is situated at Murshidabad, Lord.
But whether the medical facility is available or not,
That instruction I will have.
is the instructions you are required to get. How long will you take?
Lordship, tomorrow. tomorrow.
By tomorrow. Get it on Friday?
No, let it be on Monday, my lord.
Monday. That's for the last order. 2025. Everybody done. Completed it. Completed it. Practice with the man. Okay. That is so the court that the choices given by the petitioner include Hyderabad and other Hyderabad district include Farakka. It will be the CISF unit, the district of Hyderabad is located in Farakka. And it falls under the administrative control of CISF or the sector license open headquarters. So if it reflects that together, for the petitioner's brother, huh?
No, my lord, son.
Son.
He is in the last stage.
Suffering from chronic
Kidney disease. Stage 5.
kidney disease in pregnant stage 5. So that its treatment will remain unaffected and wait for further time. Let the matter be taken on Monday. 9th. 9th.
My lord, interim order.
Interim order passed.
Right. Order.
Please, your lordship. I am appearing on behalf of Ishram lordship. We are not getting any instruction from our client lordship. Clients are not connecting us.
No steps have been taken by the although attempts have been made to make the petition no information about them. That becomes the matter. For not you're not getting instruction from your client. We are closing it. It reported and with them but that account governor will take it.
Lordship, 1 and 2.
Deeply.
Official dated 4/25, months of notice for respondent 1 returned to the registry but without any postal note. And so far, steps upon respondent number 2 and 3, neither ready nor answer of notice is received.
One
answer of notice is returned but without any postal note. And so far,
you're reading two which office?
Office note dated 2/4/25, Lordship.
425.
Lordship.
Unserved, no ID card, and unserved notice received for R1 and R2. You want to take press step?
Lordship. Pro Dusty, Lordship.
Petitioner, please for undertaking press. But and the office ID card or the answer has not been feedback. Press step I registered affected on the front, but in 4 weeks. That's okay. But in the on the spot, but in I put it
obliged. May it please your lordship. Lordship, as per office number 35 2025, lordship. As per office number 35 2025, lordship. And the notice has been delivered to the address, lordship.
As per office 3005. Right. See that posted track record. Reflect that the notice was delivered. He had received 10/25. What is it? Or sole respondent.
Sole respondent.
It was a bit served. You notice that served. Can you take dusty?
It is difficult to take.
Let the matter be listed. Yes, or good. Can you take the sole respondent? You it's taken after 3 weeks.
Lordship. Oblige your lordship.
Yeah, please, your lordship. Your lordship will file an affidavit in reply to the statement opposition filed by the respondents. But it is not in record.
I am appearing for respondent number 3.
Is the writ petition
In the contempt.
contempt? Is something to do with promotion?
Lordship, what happened? Yes, sir. Direction was given to the authorities to consider his case for promotion. In the meantime, he retired. And as per my information, that was PPC was held, and his recommendation was sent to the ministry for confirmation. And in the meantime, he retired. If the lordship is given promotion, only the will get direction is at page.
I think after to the reply, going to affidavit, right? The affidavit, right? By needs to verify the affidavit.
Lordship, respondent number 3 may be allowed 10 days time to file that.
Your lordship, a date may be fixed.
The respondent number
3.
Permitted 5. The 10 days. At least after 2 weeks.
This miscase has been filed to come to take 3 months time matter by the order matter. The order was passed on 7/1 25, my lord. Your lordship may see the order at page, my lord, 17. Only thing was some page 21, the operative portion of the order, era 7, my lord. But she is getting provisional pension, my lord. Only final pension has to be completed, my lord.
Final pension and the other areas.
Yes. She is getting it, my lord, but only thing we need 3 months more time, my lord, to settle it.
Because the order has been passed on 18/1/2025, and I have just submitted my representation on the 17th January 2022. And the same person in the petition.
So they want a little more time, we'll give them some time.
So, Lordship, yes, it is true.
Mr. A. Roy, applicant. Studied AP. The applicant can file extension of time. How much time?
3 months, sir. The date of the filing.
It's
Not 3 months, this is 2 months. So, 2021, I
apply with the direct. The order. Like, might say no. It's both of it. Direct. Important. Compute the dependent and able to how reach coming by taking in date of the time 301,008 and the balance amount it being a year. Please paper the entire exercise direct and out the right some that the matter the respondent are active. The respondents are process of taking all steps necessary and new compliance direct so fast. However, say we completed the period of 3 months, then by them murdered and so on. Perhaps Hetri on the other hand,
2 months. Because on 2021, I have been ordering it. And they have served me on the 5,300 something the provisional pension. On
that
this provisional.
you have received some pension.
No,
We are receiving provisional pension is being
for a
paid.
provisional pension only 5,360 rupees. It's very less.
Criminal pension. Prayer for 3 months time. Considering the sufficient and also directing petitioner granting the applicant further. Do it within 60 days.
Let it be, I'm seeking the outright so that I don't come next time, my lord.
60 days.
We'll try to settle it now.
That computation required made by applicant people the entire
So my
apply with the direct order. It made clear that if the direct contained in the order, path not completed in the extended period of transport.
feel that my
Feel that
my provisional the pension
Till-
to be paid.
till the time
This cannot be.
did you the repeat the provisional pension? They continue.
Yeah.
Wait. Your party is here. What I Sir. Dispose.
Overall.
Right.
Pilot here, earlier pilot one IA was filed, IA number 317 of 25. Your lot will find page number 8. That IA malot was filed for correction of the address of the respondent number 9. And malot that I was disposed of malot by the order dated malot 5/3/25 malot page number 12.
But there is some typical error, madam. Only for correction of the typical error, madam, this I have.
Yes, what is there?
Page number 12, my lord. Second paragraph from bottom. Page number 12, my lord. Here, my lord, the applicant is permitted to make necessary correction in the postal address of respondent number 9. The applicant will now file an amended postal reflecting the correct address of the respondent number 9, namely Srimati Mishron Bibi. And only this much correction is required, that Srimati Mishron Bibi, not Mishron Bibi. It ought to have been Jamila Bibi. So, my lord, while my lord, as per this order, my lord, I file amended post title and took step, my lord. Registry, my lord, refused to, my lord, take my steps, my lord, only because of this, my lord. I don't know. Instead of Mishron Bibi, my lord, it will be, my lord, Jamila Bibi.
Yes, any object?
No, so I'm appealing for the respondent number 10. Private.
Right? IN number 7. What was the earlier IN number?
317 2025. Page number 8, man.
7. By order dated 5/25. By allowing prayer. The address was not 9. Court and granted the prayer and directing the applicant to file amended order. Technically corrected the respondent number 9, namely delayed and content of the applicant that the 9 not Mishra BP but Jamila B. To that extent, the IA has been filed the correction 2025 part 17 of the where we not affected by the content of the order for the of that respondent 9 of Webit Jamila B instead of has been reflected in the order dated by past 9 according to the out the respondent number 9 will be read as Jamila B instead of something as reflected in the order dated past 9. Present I said both of the order past week this I read together dated by past 9. I accordingly set allowed this of the amended post site and applied by applicant. You are the writ petitioner.
Writ petitioner.
You can read within 1 week from
Already, my lord, has been filed earlier, my lord.
file it again with the correct.
Mal. Apology. This I have for improvement of new incumbent, my lord, number 7, my lord. In place of number 3.
Any objection?
So, my lord, in fact, my lord, the commissioner and secretary of the finance department is thought to be implemented. Let him be implemented, my lord. Lordship may be pleased to issue regular notice.
You're not issuing notice. Will
already
grant them, will allow the I implement them and then in the contempt petition will issue notice.
Yes, yes.
I stand allowed. Opposite party. Commissioner. Made a response 7. Similar order right. The contempt right that the terms of the order so has been added as response number 7. The petition petitioner will file affidavit right the registry within 1 week. Okay. There are dead notice issued. Are you accepting notice?
Let it be sent.
Seven by registered post ID within 1 week from today. Dusty those are registered. Mr. R. Borpuzari appears for.
I have just been, my lord, requested to, my lord, assist this court.
You are appearing for all the other respondents. One and two also earlier. Doesn't matter, but appear one, four and five. Sorry, 5 and 6. Please again. After return.
I'm so obliged.
This matter is relating to non-payment of some remuneration to the panchayat representative. A bunch of
Non-payment of
remuneration of panchayat representative.
non-payment of regularization.
Non-payment of remuneration.
Remuneration.
A bunch of writ petition has already been disposed of by this honorable court. We may dispose of in terms of that.
Yes, panchayat.
File.
Huh?
We have to reconstruct the file. Wait,
You have to.
reconstruct the file.
Reconstruct.
Why file disappeared?
Let me replace.
What is the judgment?
Yes.
What is the party name?
Paragraph 39. 40. Paragraph 39.
You show her the judgment. If she agrees, we'll dispose it off. We'll come back and we'll take it up in the second half. Go to the judgment. Tell her. Yeah.
Prospective as per office note dated 35/2025. Prospective arbitration furnish the disclosure in office.
Alright. So we'll appoint him with for the respondent.
Okay.
K. Gogoi.
Yes.
Where is Mr. K. Gogoi? better you inform Mr. Gogoi, we dispose it of it is present. Let both councils are there. You inform him, if he is here, we'll take it up in a way. Hey, Gogoi. Hey.
Due to arrest of the petitioner in connection with a criminal case, my lord, I was, my lord, suspended, my lord. Subsequently, my lord, I filed a bail application, my lord, that was allowed, my lord. And after, my lord, filed a representation before the respondent authority, my lord, for instate me on service, my lord. I filed my representation on, my lord, 18/11/2023, my lord. On last occasion, my lord, it was applied before the court, my lord, and also an order was, my lord, supplied, my lord, on last occasion, that is on, my lord, 11/4/2025, my lord. It was, my lord, appears, my lord. Review was made, my lord, on 4/7/2024, my lord. That is, my lord, beyond 90 days, my lord. So, my lord, my case is covered by, my lord, Ajay Kumar Sotri case, my lord. Okay, my lord, suspension on, my lord, 6/10/2023, my lord.
Corrected are like different.
Rules, my lord, if we go by a subsection, there is a, if we interpret otherwise, it calls for suspension till the end of the criminal proceeding. नहीं कुछ हुआ। ऐसे ही बोला था।
You are suspended at the 6/2.
6/2, my lord. 6/2. 6/2 तो जमा नहीं बोलता था।
It's a deemed suspension, my lord.
Yes, my lord, if we go by C, if we interpret it very, in a very
C,
my lord,
C what?
of the 6C, my lord, C.
No,
6C.
he's at the 6/2.
6/2, but my lord, if we go to 6C, till this, it can be perpetual suspension. We are not only that, my lord.
6/1 is where there is an order of suspension.
Yes, my lord. There is no one in the.
You place him under suspected for ABC. But 6/2 is where you are detained in custody, exceeding 48 hours.
48 hours.
You are deemed to be suspended.
Yes, ma'am.
And, my lord,
effect from that date.
and, my lord, the manual of departmental proceeding, my lord, 2.1.8, my lord. So this, my lord.
My lord, it seems, my lord, it was reviewed after 90 days. Let's see. Let her be reinstated, and then we can extract some work from our part. It is sitting idle, enjoying, my lord, without prejudice, so cause, my lord. Without prejudice, the DP, my lord, lordship may reinstate her.
You pass an order for reinstatement.
It's not the power again.
You pass an order. There is already a circular. There is no counter affidavit filed.
My lord. You just fix the instructions on.
You file it. You file your affidavit.
My lord.
In fact, my lord, on like last occasion, my lord, instruction was placed, my lord.
What is that instruction? That 4/7.
Lordship, my lord. Last order, my lord, it is reflected, my lord. Kindly have a look at, my lord, order dated 11/4/2025, my lord. As directed by this court on 7/4/2025, Mr. I. Waterwell, standing counsel for the PSC department, has produced a copy of the office order dated such and such, which indicates that the review of suspension of the petitioner was done after the expiry of 90 days from the date of filing representation. So, my lord, it's clearly covered by the, my lord, Ajay Kumar Sotri case.
No, it's fairly covered. You'll have to also take it to the roots. The rules under which you have been suspended. Deemed to be suspended. There is no clear provision. But there is a circular of the government.
And in that is one aspect. My lord. Otherwise, my lord, the manual of the departmental proceeding, my lord,
Do you
is
have
also
the circular with you?
that circular, my lord.
Circular issued by the chief secretary?
মোৰ লগত নাই কিন্তু আছে পজিটিভলি মানিব লাগে বুলি কয়।
Circular of the chief secretary.
Yes,
OM.
my lord.
There's an OM laying down the procedure how the procedure with regard to suspension. Mr. Goi, give us the circular.
I have to take some time. It's not with me. I have to find out.
You get it? Wednesday?
Yes.
We'll have it on Wednesday.
Public.
Please take it on Wednesday by the starting on the forest.
No, it's speech.
PH will place before the court the circular issued by the government. Circular / OM issued by the government. Laying down the procedure for reviewing of suspension. Respect of government.
Public.
Please take on. Yes.
Already my brother has informed that he has obtained the.
Have you seen it?
Yes, sir. I have not seen the certificate, but he has said.
We want your presence to tell us, do you have any objections or not?
No, I have no objection, Lord. Just because I have no rule even in that case, Lord. I am representing respondent of two lots.
The arbitration with regard
In respect of respondent number one lawsuit, dispute between respondent number one and
not railway.
not railways lawsuit. Otherwise, lawsuit they have appeared before the lawsuit that before the mediation center of our High Court lawsuit.
Which failed.
But they have not turned up in the lawsuit main case.
Right. But
Respondent number 2 is a necessary party here.
Huh?
Respondent number 2 is a necessary party to the arbitration proceeding. As per clause of terms and condition of the
he
arbitration.
has no objection, he has no rule.
Yes.
As per earlier order dated 5/25. The it is appointed presiding officer. Respect of the difference arising between the party, arising between the petitioner and the one. The agreement of respect for the respective party. Will right. Everything. Party. Because decide arbitration. According to the application, confirming the appointment of the retired judge, acted presiding arbitrator. I think it is one. Respect to agreement number.
And let me indicate I am appearing on behalf of respondent of two lots.
Two
Lawsuit.
get a copy of the order communicated the presiding officer, the tribunal by the next. So, petitioner will also appear before the tribunal and is certified. We are not fixing a date, but we are
Asked over for the time being. But if otherwise the petitioner has got the relief lottery, we have already released the substitute allowance lottery. Can be taken up next week.
passed over for the time being. Yes. Tell us.
This is a
Get
matter,
the relief.
but the amount has not been paid yet, Your Lordship. As per the order.
All right, he'll pay the amount.
Yes.
The heard from the department. Commissioner that would support being a director for the of consistent allowed. During the course of the proceeding, department has sanctioned the amount of the General Council for Health. Department, Mr. You have any instruction?
Yes, Lordship, I have filed my affidavit document page 21.
It is included there.
Yes, Lordship, page 21.
Page 21.
Order.
The evidence by the department that makes it one. The respondents have agreed to grant salary and allowance. This office order 6 1 submitted that over the demand. That view of the order that is 125 over the demand. Survive. That although the order is passed, the amount has not yet been paid. According to the stands rules, in view of the order dated of the amount payable to the as expeditiously as possible with the aftermath of 3 months of the date of such right receipt of such right,
If not already paid.
if not already paid. For appearing for by the company.
Highly obliged. Here in this case, we are filing the affidavit during the course of the day, Lord.
Covenant in the affidavit. We have to respond by the body and to be did after 4 weeks,
Really fix it.
by which time the petitioner may apply to the joint affidavit to advise the that
Lordship may kindly fix the date. Lordship may kindly fix the date.
like
Obliged. I have filed my affidavit to transfer of an anesthesis Lordship of PSF.
I was praying for 2 weeks time. I'll have to file my reply in that.
yes,
Lordship, it's a short affidavit only, Lordship, it's not an affidavit in opposite. Anyway, Lordship, in that case also, Lordship, I want to fix that because it's becoming little bit difficult in Agartala.
what have you stated? Yes, that is required.
Yes, Lordship.
Not it.
Shortage and we are ready to give 90 days at one time. At 365 days at one time is difficult because there is necessity and so we can provide her 90 days. At
Get right, but whether you are allowed,
we will provide 90 days that we have annexed the document.
you can provide or you will allow to provide is all right. But what does the rule that you say?
Rule
Can you curtail the
no, Lordship, it's not nowhere it's stated that it has to be 365 days in a. Our rule say that it cannot be more than 3 times in a year. You can avail it not more than 3 times in a year, and it should not be less than 5 days in one. And some cases are there, Lordship, Supreme Court judgment where there is a disabled side, then you can sort for. And that also see the facts of the case, Lordship. Here it is an anesthesis in a defense, Lordship. And her on the ground is that her one of her elder daughter is appearing for class 10, Lordship. Considering all that,
And some adjustments she could make along with her husband also, who is also an ophthalmologist in Negrim's lordship. We are not denying, but 1 year a little bit difficult, Lord.
Husband is also in the.
No, he is not in defense. He is in Negrim's Shillong. So some adjustments she could make. And the rule says it's only for class 12. There is no provision for class 10 for considering the transfer. But CCL goes, but we can provide it only 3 months. And
Right. Submits that the affidavit has been filed and stating that BSF,
yes, Lord.
The BS.
BSF agreed to run for child care leave for a period of 3 months at a time. Mr. Mazumdar on the other end, enter the and wait for 1 week,
10 days.
10 days.
The 13 or 16, Lord.
How can week be over in 30?
No, he said 10 days, Lord. 10 days will be over.
Not 18. Have it paid.
Married.
Pass earlier to continue with the next week.
One small aspect, my lord, I would like to remind my. Yesterday evening we had a discussion. I'll go for an expedition reply, and I was not prepared. Please start talking the question. I was not very prepared.
I have not objected for.
But this is a discussion not known to the court. So,
My lord.
This is a discussion you did not have in court.
True, my lord. But it's not that.
So we have
Obliged.
nothing to do. We have no role here.
Obliged.
Getting something that I think. The matter, my lord, pertains to regularization and my lord, salary for a particular period. My lord, from November 99 to my lord, February 2000, Lord. My lord, the petition was appointed on 29/6/1994 as junior instructor, electrician at ITI, my lord, Sri Puna on ad hoc basis, Lord. My lord, in 1997, a process for my lord, regularization, my lord, a notification was issued, my lord. In that terms of that notification, I applied, my lord, other, my lord, junior instructor to applied lordship, my lord, I successfully, my lord, completed that, my lord. But in my place, lordship, some other's name was written, lordship, in the select list, lordship. In this way, I was deprived, lordship, my lord. Thereafter, my lord, a process, my lord, was initiated. My attempt was taken, lordship, to, my lord, terminate their service, lordship. Then my
You have been terminated. Really?
no, lordship, not terminated. Never communicated to me in any order, lord.
You were in what provision?
My lord, on ad hoc basis, lordship.
Ad hoc.
Thereafter, I approached on this honorable court, lordship. This honorable court, my lord, by interim order, my lord, protected me, my lord, not to oust from service, lordship. I was continued in service, lordship. I had never, my lord, my lord, I had been never, my lord, ousted from my service. Attempt was there, that is why I approached this honorable court, my lord. Kindly see.
What happened to the interim order?
Interim order. In terms of interim order, lordship, I was, my lord, formally, my lord, continued, lordship. That is, my lord, page 34. My lord, the first of my lord, interim order kindly be seen, lordship. My lord, page, my lord,
34.
My lord. Interim order, first, I'm sorry, lordship. At page 21. Lordship.
Page 34, Lordship. This is, my lord, formal order was passed. Married Lord. In pursuance of Honorable Guwahati High Court order and government direction communicated by letter number so and so dated 23/4/2002, Sri Haidar Hussain Lashkar, Junior Instructor Electrician ITI, Trikona is hereby allowed to continue in service in his service and placed against the vacancy of Junior Instructor Electrician at ITI depot, which carries the same scale of pay and is born in the same cadre as that of his original appointment until further order. This is formal order, Lordship. My lord, before this order, my lord, I was continued, Lordship, in service. I had never been, my lord, discontinued, my lord. Interim order, kindly see, that is at page 22, Lordship. That order was passed, my lord, on 1/12/1999. At that moment also, my lord, I was in service. Lordship, page 22, kindly see, Lordship.
So this interim order was vacated.
Sorry, Lordship.
Was the interim order vacated?
No, Lordship.
Where is the interim order?
My lord, page 22, Lordship.
Passed in this case? No.
No, another case, Lordship. I am in service, Lordship.
Page number 22.
22, Lordship. In earlier litigation, Lord.
Then what happened in that?
My lord, in that case, my lord, interim order, my lord.
What happened to the writ petition?
Writ petition was disposed of, Lordship. That is, Lordship, kindly see at page 39, final order. Page 39. My lord, it was disposed of, my lord, in terms of other petitions order, Lordship. Married, Lordship. The facts of the case are identical with those in WPC number 245 of 1995, disposed of on 29/11/2005. It will therefore not be necessary
in WPC 245.
That is not, my lord, annexed, Lordship. But here in this, my lord, observation, it is, my lord, stated, Lord.
But what is that order? What order was passed in 245?
My 245, that is not annexed, Lordship.
The order you are referring to says that similar order is to be passed.
In this order, my lord, this observation is there, my lord. The facts of the case also, my lord.
But what order was passed? What order was passed in 245?
That is not annexed. Then, my lord.
No, that is not annexed. That is not reflected. That is not discernible from page number 40. You tell me, reading page number 40, what order were passed in 45?
245, Lordship. Other writ petitions also, my lord, was disposed of, Lordship.
With what order?
In the 790.
What order was passed? Was it allowed? So
then, my lord, 1 week may be allowed. I tried to collect that order, Lordship, but very 2005 order, Lordship, but he was not able to, my lord, provide, Lord.
45 in 99 order.
2099 order. Yeah. Then, my lord, 1 week allowed. That may be allowed. I will try to, my lord, get that order. Mr.
Das, you have that order?
No, my lord. But as per my lord, our affidavit, we have annexed the termination letter. He was terminated. At page, my lord, 65, my lord.
Get the order.
My lord. Order on
both parts.
Yes, my lord. My lord. Order on
Lost. That may be. It is in your file.
contain the big but that I think but allowed I did but but big very fast the what type or it's again after 2 weeks.
I'll pay for a date loss.
Noted. After 2 weeks.
The proceedings are completed, madam.
You bring it on record with the after 2 weeks.
Loss.
Make a mention.
Yes, correct.
Any instruction?
Yes, I will take it off. Yes, I will take it off.
None appears for the petition in court and here the and the matter was called for 21/7. 7/8. Voting it. Not right. I
Read your lordship. As per my senior instruction, matter may infrastructure.
counsel for the petitioner appearing the on instruction setting either yes.
Message file challenging a dismissal order. The bank has filed their affidavit in opposition. Will like to file an affidavit.
Sir BT Moral raised for 2 weeks time. File reply affidavit. The affidavit. Right.
Yes. Regarding proceeding record, lordship.
You can keep it.
That is also filed as annexure 1.
You have filed it.
We have already filed. If your lordship wants the original, that is a different issue, lordship. Your lordship may be please. After vacation, it's for here.
After be listed again after how much time you require? 3 weeks. It's again after 3 weeks.
Any date I can get quick.
Or lordship. Or hearing.
For
admission. For
Admission hearing.
Or you want route to be?
No, lordship.
No, lordship. What happens if the record is not required?
No, we don't know if it is required or not. Let us
Okay.
go through your affidavit. If we require, we'll direct.
Let
it.
me see.
You have the record with you. Do you have the record
No,
with you?
the record we have filed. So I have also not probably gone.
At the time of hearing,
Lordship.
we find that the original is required for some reason. We requisition.
Yes, Lordship, if I get, otherwise the record is before the Lord.
Otherwise,
That is there.
you have filed it in the affidavit.
Lordship.
Deeply.
Obliged.
My lord, matter is relating to appointment of Anganwadi worker. And in the year 2009, an advertisement was there and relevant portion is at page 35, man. Page 35. Serial number 88. My center is Matia Coronarty Kibir A. So I have applied, submitted all the documents and got secured highest mark and was appointed. Thereafter, my lord, the private respondent, that is respondent number 4, filed one writ petition in the year 2010, challenging that I am an outsider. So that was an affidavit of reply has been filed by the respondent number 3, the then Child Development Project Officer. And in that affidavit also said that I am within that center. Thereafter, my lord, that writ petition was disposed of by way of order dated 9th of February 2018, saying that the respondent number 2 shall hold an inquiry, giving opportunity to both the parties and give one speaking order. Thereafter, my lord, an speaking order was passed dated 15th of November 2018. That is important, my lord. Annexure 9, page 50.
50.
50, yeah. Annexure 9. My lord, here the third paragraph from the bottom, that is the observation. Peruse the report. May I read, my lord? Peruse the report submitted by the Child Development Project Officer Matia ICDS project, wherein it is revealed that Srimati Suruchi Sangma, that is the writ petitioner in the earlier and private respondent in the present, is a resident of Posim Kodamtala village who belong to the operational area of Matia Soranaki Sibir A302 Nong Anganwadi Center. Whereas the respondent number 4, that is the petitioner in the writ petition, Dolita Roy Nath, wife of Hori Prasad Nath, is a resident of Kodamtala village, who does not belong to the operational area of the Matia Soranaki Sibir A302 Anganwadi. From this observation of and report of the CDPCPO,
What is your name?
my name is Dolita Roy Nath. But this is important, my lord. Village is same. One is Pachim Kadamtala and mine is, as per the report, Kadamtala. Now, in this, my lord, village, the western side of the village is not told as a Suburi, but as a Pachim Kadamtala.
But how will the court find out? The western side, eastern side, which?
My lord, yes. That is why.
What is the mechanism to find it out?
That is why one reply has been filed already by the respondent number 3 in this writ petition.
Who is respondent 3?
That is the Child Development Project Officer. He also said that I am within the area of Pochim Kodamtala. And as per the advertisement,
You are challenging this order or which order?
no, my lord, Annexure 9, my lord.
You are challenging this order.
Yes. I am still continuing as a.
But this order is pursuant to the order passed by the High Court.
Yes.
In that petition, you are a party.
Yes.
Then
So, my lord, at the time of advertisement also, I have submitted all the documents and the certificate issued by the local authority. That is at page 29.
What do you say?
Lordship, as per the order dated 9/2/2018, pursuant to which Lordship the speaking order was passed. In that order, Lordship, the writ petition was disposed of with the direction to the respondent number 2 to verify the matter by giving opportunity to both the parties for a hearing and Lordship to produce necessary documents and thereafter pass a final order. And pursuant thereto, Lordship, this speaking order was passed. But Lordship, as per this affidavit of respondent number 3, CDPO, paragraph 9, Lordship, it is an admitted fact that Surachi Sangma, whose candidature was rejected for her failure to secure higher marks in the interview, challenged the appointment of the present petitioner, Srimati Dalita Roynath, on the ground that Dalita Roynath is an outsider by WPC number so and so. The deponent further begs to state that it is verified from record that Srimati Dalita Roynath is not an outsider and she is a permanent resident of Paschim Kadamtola village, Motia.
I married, my lord, and have 2 children. And my husband is a permanent resident of Paschim Kadamtola, and certificate is also there. And the report also said only confusion Paschim or Kadamtola.
Report by who?
Report by the, my lord, page number.
This Annexure 9 order.
Yes.
Is it based on some report by circle officer or somebody find out?
No, my lord. As I understood, my lord, the respondent number 2 passed this order only the report of Child Development Project Office. Nothing else. I have submitted all the documents, but no.
Child development has the same child development has filed his affidavit.
In the prior writ petition also, I don't know whether this person was same or not, but in the WPC of 2010, an affidavit had been filed by the then CDPO. That is at page number, my lord, Annexure 7, page 42.
What is this report here? Where is the report? Where is the report at page number 9?
Of the same area, Lord. Matia.
You take out page number 50.
Yes, sir.
This is the report, this is the order passed by the director.
Lordship.
Somewhere little below the middle, you'll
Yes.
find there's a report of the ICDS.
Yes, so this is someone.
CDPO.
Yes.
Where is that report?
Okay.
Not here.
That is also not applied to me, my lord.
So let me get it, Lordship. Let me get the report of the residential status.
Interesting part, my lord. Kindly come to page 42, my lord. Annexure 7.
Ultimately, the issue is of the residential part, whether she is a permanent resident of.
Yeah. Page 42, Annexure 7. And this is the affidavit filed by the CDPO at the earlier writ petition. So he also admitted that I am the resident. So at the letter it says, how come this new report has been, my lord, submitted?
Let us see the report.
My lord.
Yes. Because it is the same issue, bypassing
the issue, the dispute between the petitioner and the respondent with regard to appointment as Anganwadi worker in Matia Soronarti in bracket A, bracket 230 number, Anganwadi center. The petitioner was appointed the state center as party worker, put to challenge by private respondent earlier by state writ petition. So directing director social welfare verified the matter by giving an opportunity of hearing both parts, both and also by permitting them to the document. Thereafter, fine. Correct. It deference to the director elected by the order number 12 dated 8 November 2018 as passed viewed in the and as notified that the petitioner does not belong to the operational area of Montia whereas the private respondent number 4 belongs to your state. The state order states that the report has been referred and was relied upon. That an affidavit by the city people has been filed where it stated that the petitioner is not an outsider and the permanent resident of positive one of the Babylon India and is married with its government is made as 9%. In the view of the side of the issue, court direct respond the government produce the materials the basis of which the director will name past dated 15 November 2018. So the report stated to have been submitted by the scheme via IPS project and which is found referred in the impute order will also be placed in the report. It's taken after 2 weeks.
In the meantime, interim order dated 19/12/2018 may be continued.
Let us have it in July.
Well, 19/12/18.
Listed again.
Perfect.
So July. The order passed on 19/12/2000 will continue the next day.
Right. Also.
No.
I don't know. Reply has not been filed.
They have filed a reply here, Bharat. And in fact, here the petitioners have brought upon this onto court because the petitioner had earlier filed a writ petition and it was dismissed. We have annexed that order of affidavit in opposition, which is at page number 32.
I haven't.
Yeah, fine. Next. 15/7/20. There has been a change in council. Perhaps Leonard Penn has not received.
I haven't received a copy of it. I have to take instructions from my client.
Counted for the petitioner by taking time. Receive. You are newly subsequently engaged in the writ petition.
Yes.
This writ petition.
Yes. Earlier there were other set of
As it has been subsequently. Right. Bora. তারপরে
Deeply of note.
Mr. Lordship, hearing on behalf of Mr. K. Talukdar, with the consent of the other side, I'm seeking for accommodation in the matter, Your Lordship, some personal difficulty.
Here, counsel for adjournment of the matter. It's after.
2 weeks, sir.
Did it come after vacation?
Well,
It is immediately after the summer vacation.
Deeply, Your Lordship.
Alex, can I pray for a date?
Right?
Well, great.
Deeply, Your
Lordship, I have communicated the order of this honorable court for his lordship, H.N. Sir. He has accepted it verbally, but he is yet to issue the. Yes, can this matter be listed again on lordship? 13-6 lordship. There is another matter where he has been appointed. It's fixed on 13-6 lordship. Together we can.
Right, Mr.
DJ.
Your name?
DJ.
DJ Kapil. Counsel for the petitioners of that pursuant to the order dated 5/25 issued by the respondent by the court. The order was duly communicated respective of the Justice Sharma or judge. Okay. So Justice Sharma has verbally expressed his accepted act as how the written declaration as required of the well. Yeah. Act. Counsel is for the fact. It's up that it's a matter. So, people.
30.
Prayer made. Next again on 13 June.
Hello.
May it please your lordship. Lordship, in this matter, I am appearing for respondent number 4, private respondent. I pray for 2 weeks time to file our affidavit.
As the last chance, earlier they have also taken time. But as per my knowledge, DPC was already held on regarding promotion to the post of senior assistant to superintendent. So there was the last chance.
You are representing which
Private respondent number 4.
four. Who's for the other respondent?
Lordship already department file affidavit, Lordship.
Counsel for the private respondent. Pray for government bank. There are four. Three. What five reply? Five. Reply five.
Not necessary.
Right. Right. Which is one? Again. Up to the
Obliged.
Date
20. Appears for the order. Yes.
In this case, my lord, the petitioner, his, his father died in harness. So immediately, as there was no regular second post, he was appointed as officer's employee. And thereafter, my lord, he has been granted all the regular pay scales, etc. But his post has not been regularized. If it is not regularized, he will be deprived of his service benefits later on. So it is an exceptional case because it is a compassionate appointment, not a regular. And except for
But compassionate appointment has to be regular.
yes.
Where is the question of compassionate
My
appointment?
lord, he was not appointed in any regular post.
So then where is the compassionate appointment?
Yes.
Where is the appointment order?
Yes, page 24, annex 4. In the interest of public service and in pursuance of letter number so and so, my lord, Shri Kulojit Das, son of late Nagan Das, ex-driver of this division, is hereby appointed as WC handyman on compassionate ground in the pay scale of so and so, plus other allowances as admissible from time to time, and posted at proper time.
Compassionate appointment has to be regular. How can you make him? Where was his father working?
Inferiority, my lord, ex-driver of the division.
Regular appointment.
Yes, regular appointment.
So what does the affidavit say?
Affidavit says something other things, my lord. They are not mentioning about the compassionate appointment. They are mentioning about the general workers and casual employment. It is not that in that category. It is purely compassionate appointment.
Where do you have the judgment?
It is not with me now.
How you get?
It may be fixed on.
After 1 week?
Yes, my lord.
After 1 week.
That may be.
Address the court that compassionate appointment made. Any appointment regular appointment. After date. That our court sitting up that the affidavit is already right. It again on after 1 week.
Hello, in this matter, as per the last order, my lord, up to the instruction was sought for my lord with regard to the departmental proceeding pending against the petitioner.
Where is Mr. Nayak? PWD.
My
Any
lord,
instruction?
I am there.
The next set.
My lord, that will be brought in the record.
We'll bring this on the.
Bring it on. Start for- Okay. order be brought before. Fine.
If there is any,
We have-
if there is any further, my lord, review, that also I'll bring on.
As well as more supplement review. Let this affidavit be filed within 2 weeks.
My lord, I will take back that.
Yes. Take it. After
My lord, I need further 2 weeks time to file my reply.
counsel for the petitioner raised the claim to file. They have made out of it with substance.
There is an interim order, my lord.
Interim order passed by the
Oblige.
Lordship, we have received instruction, Lordship, taking consideration, considering this, Lordship may dispose it of Lordship. Lordship, we have an instruction,
We'll take it up in the second half.
Lordship.
Counsel the petitioner.
It's covered.
Party.
Thousand 23 2 GLP 605.
Lordship, we have received instruction in this matter, Lord.
I have gone through the advertisement, my lord.
I also shared.
Our application has been, applicant's right has been protected.
No, Lordship, there is a new advertisement, but that advertisement, those who have applied on earlier advertisement, they are also covered with this. And it is specifically mentioned in the advertisement, the first paragraph itself.
Yeah.
fresh advertisement it is 27/5/25, Lord. 5/25. Okay. And in the first paragraph, it is mentioned, Lordship. I have shared the
Last line.
vernacular, these things, Lordship, vernacular copy of the advertisement. অসম চৰকাৰ মহিলা আৰু শিশু উন্নয়ন বিভাগৰ চিঠিৰ নাম so-and-so, শিশু বিকাশ প্ৰকল্পৰ বাবে খালী হৈ থকা অংগনবাড়ী কেন্দ্ৰসমূহৰ বিপৰীতে অংগনবাড়ী কৰ্মী সহায়িকা হিচাপে স্বেচ্ছাসেৱা আগবঢ়াবলৈ ইচ্ছুক মহিলা প্ৰাৰ্থীৰ পৰা আবেদন বিচৰা হৈছে। চিঠি নং so-and-so dated 13/12/22 মৰ্মে যিসকল প্ৰাৰ্থীয়ে আবেদন কৰিছিল সেইসকল বৈধ প্ৰাৰ্থী প্ৰ-পত্ৰসমূহ গ্ৰহণ কৰা হ'ব। So this is their Lordship.
Last part of the subject.
Lordship, here it is a
By distinguish, no press documentation. But one candidate, her earlier center was abolished.
they will apply according
One
to her.
candidate.
Yes, Lord. Lord. Lordship. Deeply obliged.
May I please your Lordship. Next senior is appearing from DC, madam. Yes.
Lordship, I'm not audible, your Lordship voice. My friend is here. I can hear his voice, but your Lordship, mic perhaps.
Is the court audible?
Yes, your Lordship. Deeply obliged. Yes.
Yes, please.
Your Lordship, kindly see your order dated 27th of January, where your Lordship heard this matter elaborately, and then your Lordship observed that it can be disposed of on the next date of hearing. And meanwhile, your Lordship, after 1 or 2 days, directed them to file some documents. They have filed it. They have filed the reply. Your Lordship, the small controversy in this matter is that there is a arbitration clause admittedly by the respondent also. They have not replied the notice. They have not replied the petition. They have not replied even in the earlier round of litigation. So, Your Lordship, I am squarely covered by Goki Technology Supreme Court, where Your Lordship, with
I
all
think
due
they raised an objection that the notice is not proper. I think that was the objection earlier.
nothing on record. Nothing on record. He has not replied the notice. Even the reply they have filed, nothing about the notice, Your Lordship. All they say that midday scheme and Samagra Shiksha Assam is something executing agency and documents regarding that.
Who appears for the respondent?
My lord, last time
you are not appearing.
Yes, Mr. Nayak.
Yes,
You are
Mr.
appearing in this matter. Yes, yes.
Yes, Lord, appearing. Yes, Lord.
You filed your objection.
Yes, Lord. One affidavit has been filed. But some other issues are also there, Lordship. If Lordship comes to the agreement at page 114, which one? 11, right? Agreement dot annexes. Annexes 6. This is 113, Lord.
118 is the relevant para.
114, Lord. This is the MOU, Lordship, signed between the parties. If Lordship comes to the parties, Lord, Lordship may say first party is the state nodal officer midday meal skill Assam.
114.
113.
113. Yes.
First party is the state nodal officer midday meal scheme Assam. Now, Lordship, in my humble submission, Lordship, this authority is something separate from the MDSSA law. Although both persons are same, Lordship, this is a separate authority.
Yes.
Till now, we are filing affidavit on behalf of SSA law.
They are not arrayed as a party.
He has been arraigned, Lordship.
Then
yeah.
Who is appearing?
That confusion remains, Lordship. Whether I am appearing or
We had issued notice. You did not say you did not
yes,
appear.
yes. That is my fault also, Lordship. Represented through the mission director, Samagra Shiksha. In fact, Lordship, this nodal officer, Lordship, is not required to be represented by the MDSSA. It's a separate entity, Lordship, individual authority, Lordship.
So what are you trying to say?
Lordship, there is a scheme, Lordship, PM Poson scheme. This is entirely a central government scheme.
Right.
In other states, Lordship, there is a separate director for implementation of this scheme. But so far as Assam is concerned, Lordship, there is a notification. And in terms of that notification, Lordship, state mission coordinator, the MDSSA has been given that, Lordship, if Lordship comes to page 195 of my affidavit.
Yes.
195.
Yes.
The governor of Assam is pleased to notify the mission director SSA Assam as the nodal officer for implementation of the regular monitoring of midday meal program in the state. So, Lordship, whether I should file this affidavit as on behalf of MDSSA or on behalf of the nodal officer.
That is for you to decide. How can we say on
That
whose behalf you
confusion,
want to
Lordship,
file?
recently came to my mind, Lord. Ultimately,
You have filed it on whose behalf?
SSA, MDSSA.
MDSSA. It is up to you, whatever you want
they
to
have
do. If
given
you
the
want to
permission,
file
Your
a
Lord.
separate affidavit on behalf of a nodal officer, you file it. Because the agreement MOU is with the nodal officer.
Your Lordship, if my learned friend is suggesting that they have nothing to do with the nodal officer, let the statement be
I
recorded.
am submitting this Lordship on last day.
Yes.
On last date, Lordship passed a direction asking for the constitution of SSA law.
I do not know why we are.
Lordship, kindly see the order dated
14/2/2005 law.
Your Lordship, may I
Last
submit?
paragraph law. In view of the submissions made by the learned counsel, it has become necessary to examine the particulars of the respondent authority. The respondent authority is a society. SSA is a society, but not mid PM portion is scheme laws. Society registered under the Society Registration Act 1860. Accordingly, the learned counsel for the respondent is permitted to bring on record the relevant documents which reflects its constitution or its members of the society at the time of incorporation as a society, as well as various other office bearers.
Your Lordship, may I submit?
Yes.
Your Lordship, whatever my learned friend is suggesting, all I am asking for appointment of an arbitrator. All sort of objection can be taken before the arbitrator.
This is not objection.
If
It
I
is an issue, very pertinent issue, Lordship, because it relates to that Schedule 7.
kindly see, Your Lordship, section 11(6)(a) of the Arbitration and Conciliation Act, 2015 amendment is here, Your Lordship, and 2015 amendment, Your Lordship, with all due respect at my command, the referral code.
Just 1 minute. Just
My
1
lord.
minute. Mr. Nayak, what you are saying is that since the nodal officer is a separate office,
Yes, Lord.
separate identity,
Yes, Lord.
the bar under this 12 is not applicable insofar as
So whatever, Lordship, so far as this order passed by your Lordship, this was only in respect of the bar that is that arises from the Schedule 7, Lordship. Keeping in mind that bar, Lordship, your Lordship passed that direction.
that is because you said that it is a society.
Yes. SSA is a society.
Today your argument is that it is not SSA, but the agreement is with the nodal officer.
Yes, I became a little wiser.
Huh?
It's like change of argument, Lord.
All right. You are entitled to take
It appears to me, Lordship, it's relevant.
That clarification, my lord, may I submit, my lord? The clarification can come from the annexure 7, my lord, 121 page number, my lord.
Yes. Permission given by the SSA.
At page 121, my lord, annexure 7.
(121).
Yes, my lord.
Yes.
My lord, may be pleased to see, my lord, the Office of the State Nodal Officer, Midday Meal Scheme, Assam, SSA Campus, Kahili Pada, my lord. And it was issued to us, my lord, through the Executive Director, SSA Assam, my lord. Now, importantly, the notification which has been referred by my learned friend, my lord, senior friend, is pertaining to the fact that the governor, the Honorable Governor of Assam is pleased to notify the Mission Director. Now, again, page at 195, my lord.
190.
Yes, my lord. That is the notification which has been referred.
Mission Director.
Yes, my lord. The Mission Director SSA as a nodal officer for implementation of the midday meal scheme. Now, the office bearers to that effect are one and the same only, my lord, then. And importantly, my lord, when the agreement MOU was signed, my lord, may you please to see the last page of that MOU, my lord. At page 119.
We are
yes.
We are getting a little, we are digressing into the question is of appointment of an arbitrator.
Yes, ma'am.
Yes.
I think
Yes,
the
madam.
objection you raised was that they have not issued a notice and we may be given an opportunity, I mean, you may be given an opportunity to appoint an arbitrator from your side or suggest a name of an arbitrator, which
Madam.
they are objecting, saying that it amounts to an arbitrator, curated arbitrator, and they are not waiving away their rights.
My lord.
So therefore, as on now, what you are suggesting is that SSA may be or may not be treated to be a part or of the government, or the government may have uh, supervision over the SSA, but fact remains that in the agreement is executed between the nodal officer and the petitioner.
Yes. And the nodal officer at page 154, 153, that is the cancellation order. The person is the same, but it is cancelled by the state nodal officer midday meal scheme.
Yes, Mission Director.
No. So what are you now trying to say?
My point is, this scheme is a central government scheme. And the agreement suggests that the arbitrator is going to be appointed by the state government on being referred to the state government.
Where is that clause again?
Page 118, my lord. 118.
Clause 56.
Clause 56.
Yeah.
Arbitration, Lordship. In the event of any dispute arising out of the contract between the parties hereto, and to the same shall be referred to the sole arbitration of the state government or any officer appointed by the state government on its behalf.
My lord, Parkinson is very clear regarding this clause.
This is executed in 2018.
Yes,
and the amendment was with effect from
2015.
15.
15.
15.
15, I think. Lord.
So therefore, subsequent to the amendment, all these clauses will have no consequence.
My lord.
2015, with effect from 2015.
15.
So therefore, if you now concur on an arbitrator, subject to their agreement, we can appoint.
My lord.
Or we appoint an arbitrator.
My lord.
No, the other issues remains, Lord. Other arguments I placed on the earlier days, Lord.
What are the other arguments?
Lord, first, your Lordship will see the judgment passed by the earlier judgment.
Page, my lord.
WPC.
WPC.
160.
Lordship, it's 1620, page 162.
162. Yes. That para 6.
Para 6, Lordship. Lordship, here Lordship will note two things, Lordship. It is seen that the memorandum of understanding dated 26th and 2018, the period of engagement of the petitioner was for an initial period of 3 years with effect from 1/1/2019. Therefore, the normal 3-year tenure of the MOU is found to have already expired on 31/12/2021. Therefore, as the contract is found to be determinable in nature, the petitioner is not found to be entitled to any other specific performance of the contract after lapse and or expiry of the contract period covered by the said MOU. So first issue, Lordship, the termination issue has already been settled. That is one. Second part, at best, the petitioner would perhaps be entitled to approach the civil court for seeking damages and or compensation if so advised. So
my lord,
if
para
there
9
is-
also, my lord. Para 9 is relevant. My lord,
Let him complete. Let him complete. Yes.
So far as termination part and compensation and damages part is concerned, the issue is settled.
Yes.
For termination, they have no option. They are remained with no option. And so far as compensation and damages are concerned, they have to approach the appropriate civil court. That is the finding of the court in advance, Lordship.
And my lord, para 9.
Para 9 is there. Para 9 is there. However, before parting with the record, as the learned senior counsel for the petitioner had referred to clause 56 of the MOU, which contains arbitration clause, the court is inclined to provide that the dismissal of this writ petition shall not be a bar for the petitioner to invoke arbitration clause. So it is open for you to invoke arbitration clause, but so far as the issues that has been settled by the court in advance, you cannot invoke those issues now. You cannot raise those issues now.
So the issue here is that in spite of the clause for an arbitration, disputes had arisen, the respondents are, or they want to say that the clause in itself,
Lots of.
pursuant to the amendment in section 12(5), is not applicable. So therefore, an arbitrator has to be appointed, and therefore the petition under 11. This is their case. Besides the other issues, you are trying to urge that there is no point in referring the matter to arbitration because the question.
Because of page 176, Lordship. Lordship, may kindly see the dispute. What is the dispute, Lord?
What is
Gopi
176?
Technologies
Start from
cover
Lordship.
every aspect what my learned friend is arguing. My lord, the
Start
Gopi Technologies
page
Supreme Court
173.
says that learned arbitrator is equipped enough to decide every dispute. But so far as the referral up to the arbitration is concerned, the only
176 is
issue.
a postal receipt.
No, it starts from 173. 171. No, second one. Second representation one. 21 to
171.
171, Lordship. And in that representation, Lordship, may kindly come to paragraph 12 and 13. That is at page 174.
174.
Yes.
So straight coming to the dispute, Lordship. 13. Eventually, evidently and admittedly, disputes regarding the claim for loss sustained by our client on account of arbitrary cancellation of the agreement have arisen, and hence our client, by way of this notice, hereby invokes the arbitration clause contained in the contract agreement dated so and so under clause 56. So this is nothing but damages and compensation.
No.
Paragraph 12 and 13.
But who is to decide that? Their claim insofar as damages has not been decided.
No.
It is the view of the court.
Under 11.6, Lordship, at this stage, Lordship will decide whether there is an arbitration clause or not, or whether there is any issue that is to be decided by the arbitration.
That's what we are asking you.
Lordship, this is apparent.
So far as the first issue is concerned, there is an arbitration clause.
That is there.
And in view of the amendment, unless they issue a waiver, there is no other option but to come to the court for appointment of an arbitrator.
No, even going
Second issue in view of whether damages are whether the arbitrator can go into this aspect of deciding. You see, even if we take the view to be final of the coordinate bench,
yes,
then you want to say that it has to be restricted only to damages.
yes.
Now, whether this aspect can be decided by the
No,
arbitrator.
that so far as that aspect of damages is compensation and damages is concerned, it is the clear-cut direction that it will be decided by the appropriate civil court.
Now, then you
There
have
is
to,
no other dispute.
so then you'll have to give a meaning to the para 9 of the order.
Other than termination and compensation and
What else is to be
damages,
decided?
if you have any other.
No,
They
what
do
else?
not have any other issue, Lord.
No. Therefore, you'll have to say that this order conclusively decides that there is nothing else to be done except for damages and compensation. So therefore, there is no question of going for arbitration.
Yes.
Is the arbitration, the sole issue to be decided is whether the termination is wrongful. Number one.
No, termination has also been decided. Lords may kindly see the order earlier. That issue has been.
Page number?
That is page number 160.
164.
Relevant paragraph 6, 164. Paragraph 6. Page 164, last two line, Lord. Paragraphs. Therefore.
No, what we want to ask you is, assuming that there is a determination by the court in respect of the claims, and except for leaving the question of damages and compensation,
As well as termination. First is termination.
termination,
Paragraph, page 164, paragraph 6, last two line.
last two line.
Therefore,
Hmm.
paragraph 6, last two line. Therefore, as the contract is found to be determinable in nature, the petitioner is not found to be entitled to any further specific performance of the contract after the lapse and or expiry of the contract period covered by the said MOU.
My lord, where is the finding regarding the termination?
That is-
I'm really sorry to interrupt.
In respect of
Termination was illegal, my lord. It was abrupt. It was arbitrary. And my learned friend, I don't know why he is arguing this point. Where the coordinate bench has held the termination of my contract was valid. All they say that contract period has expired in the jurisdiction under 226. I'm not going to entertain it. But you may invoke arbitration if you please, if you advise. I mean, let Goki technology, let arbitrator be appointed. They can raise n number of points before the arbitrator. If I do not have the claim, the same will be decided. Goki technology, my lord, I have.
But what do you say about the finding at para 6?
Para 6, my lord. Para 6.
Yes.
My lord, I'm reading that it is seen that by my memo is so and so the period of engagement of the initial period of 3 years with effect from on. Therefore, the normal 3-year tenures would have been expired on so and so. Therefore, the contract is found to be determinable. It is not determined, my lord. Determinable in the nature if the petitioner will be entitled for any other specific performance of contract after lapse and expiry of the contract.
Petitioner is not found to be entitled.
Not
Kindly read the paragraph.
I'm again reading, my lord.
Yes.
Therefore, the normal period, normal 3 years tenure is found to have already been expired on so and so 2021. Therefore, as the contract is found to be determinable in nature, the petitioner is not found to be entitled for any further specific performance of the contract after lapse of the expiry of the contract period covered by the said MOU. Not all the honorable court said regarding the specific performance of the contract. My contract was determined without a so-called notice, without an intimation.
Whatever it may be, but there is no specific performance. That is the finding of the court.
In the read petition under 226, your lordship jurisdiction under 226, I have claimed that please direct them that I may be continue with the project. Court said the period is over, but so a specific performance direction cannot be given. But the honorable court simultaneously said other issues are open. Not whether my contract was determined in accordance with law is yet to be decided by the arbitration according to me. This aspect has not been dealt with by the learned single bench, my lord, with my learned friend.
Let us say, assuming the arbitral tribunal proceeds to decide whether your termination was in accordance with law and comes to a finding that it is not in accordance with law, what remedy would be available for you?
For that purpose, with deepest respect, my lord, the arbitral tribunal had to be formed by your lordship.
No, what remedy is available for you?
Lord,
What?
If arbitral tribunal comes to the conclusion that it was determined as per law.
If it was not determined as per law,
then my lord, damages, compensation.
That is what he wants to say.
My lord.
That there is a finding by the court that this damages is to be sought before civil court.
My lord, there is a statutory provision. My lord, if there is an arbitration agreement, I am entitled to invoke. My lord, the honorable court, with all deepest respect, my lord, or my learned friend can't force me to approach the civil court.
So essentially, you are saying that the arbitral tribunal will look into this aspect of whether
every aspect. I will not object anything.
No. See, this order has been invited by you.
Yes,
at your writ petition.
My lord. Yes, my lord. But in this order also, the honorable court has said that if there is a clause 56 para 9, my lord, liberty is given despite
right.
dismissal of the writ petition.
Liberty is granted, but
My lord.
this has to be read with para 6.
My lord,
You can't ignore para 6 by saying that para
I'm
9
not
is
ignoring, my lord.
only effect
All
para
I am saying, my lord, I am a sufferer. If there are two clauses which requires interpretation,
It is true that the High Court under 16(11)(6) is required to not look into
my
too
lord,
many aspects, only to see
My
the
lord.
existence
My
of the
lord.
arbitral tribunal.
my lord,
But will it mean that the High Court is nothing but a post office, that you come file an application and
With
we
deepest
refer it
respect,
without
no, my
even
lord, no. If my
going into these
claim is
aspects?
prima facie bogus claim, then of course your lordship is right. I may
You
be
satisfy us that there are still issues which are required to be decided by the arbitral tribunal.
Milord,
What are the issues? What are the claims that you're going to make before the tribunal?
my lord, kindly see, my lord, their termination letter, my lord. Kindly see, and it speaks everything, my lord. Firstly, my lord, page 154, my lord, 153, 154, my lord. Kindly see. This is the 4-line order we have received. Before that, my learned friend has shown you that
We are
permission was granted.
asking you
My
to
lord.
satisfy the court that in a given situation, the matter can still be referred to an arbitrator.
My lord, kindly see that.
Decide certain issues,
my lord,
which are still open to be decided by the tribunal. Show us with some authorities.
My authorities, I will provide, my lord, but kindly see page 153, my lord.
Yes.
This is order. As per government of Assam, so and so department, decision received on so and so department, the contract agreement executed between the Assam Sarv Shiksha Abhiyan Mission SSA and NGO pursuant to the EOI so and so centralized kitchen stand cancelled. My lord, this order is shocking, my lord. At least I should have some opportunity. Where is the before cancellation? Where is the so-called notice that you have not complied this, you have flouted this, you have done this, so we are cancelling you? A state-way cancellation, my lord, without any so-called notice.
As per the MOU,
my lord,
what is the provision for damages and claims?
My lord, there is only arbitration clause in case of any dispute.
Nothing else.
Damages specifically, I don't think there is any clause, my lord.
So, tell us, how do you see, in the event the matter is referred and the tribunal assumes jurisdiction,
My lord,
right, and it decides that yes, the termination was not in accordance with law.
my lord,
In view of the finding by this court in a writ petition that you are only entitled to damages and
once
compensation.
your lordship will form the tribunal, appoint the arbitrator, I will make my statement of claim. It may be accepted, it may be rejected.
You may be, but in the face of the specific finding by coordinate bench of this court,
my lord,
can the arbitrator proceed to decide
my
without
lord,
that order?
I have annexed the bank's document which expenditure I have made for executing this midday meal kitchen. I have purchased land. I have constructed the centralized kitchen. CA certificate is there, and banking supported by banking documents, my lord. It's a PNB bank documents that I have purchased the equipment for the kitchens. All these documents are staring on me that these are the expenditure I have done for executing the.
So you are asking for only compensation or damages, not damages, but compensation.
Necessarily, my lord, because my lord, once the period is over, and my lord, I have suffered the losses, and there is a damage clause, and there is a arbitration clause. I only want to say, my lord, Goki technology is very clear. If your lordship will kind enough to see that arbiter tribunal is, my lord, conclusion. Kindly see the paragraph 16 and 17 analysis, my lord. It's a 3-bench judgment of the Supreme Court, my lord, covers everything. Paragraph 17, my lord.
Yes.
16, having heard the Lord Counsel for the parties, gone for record. 17. In a recent pronouncement, relying on the constitution bench of this court in res so and so, so and so, so and so, the Indian Stamp Act, the court in SBI General versus Chris Spenning summarized the law on the scope and standard of the judicial scrutiny that application 11.6 can be subjected to. The relevant para are produced below. 114. In view of the observation made by this court in re interply, it is clear that the scope and inquiry at the stage of appointment arbitrator is limited to the scrutiny of the prima facie existence of the arbitration agreement and nothing else. For this reason, we find it difficult to hold that the observation made in Vidya Darola so and so that the jurisdiction of referral court when dealing with the issue of accord and satisfaction under section 11 extend to weeding out ex facie non-arbitrable and frivolous dispute would continue to apply despite subsequent decision in re so and so. So Vidya Darola is overruled, my lord. 125. We are also of the view that ex facie frivolity and dishonesty in litigation is an aspect which arbitral tribunal is equally, if not more, capable to decide upon the appreciation of the evidence adduced by the parties. We say so because arbitral tribunal has benefit of going through all the relevant evidence pleading in much more detail than the referral court. If the referral court is able to see the frivolity in litigation on the basis of bare minimum pleading, then it would be incorrect to doubt that arbitral tribunal would not be able to arrive at the same inference, most likely in the first few hearing itself, within the benefit of extensive pleading and evidentiary material. Then, my lord, it goes on saying, a scope of inquiry under section 11 of so and so is limited to ascertain the prima facie existence of arbitration agreement. In the present case, High Court exceeded this limit scope by undertaking a detailed examination by factual metrics. High Court erroneously proceeded to assess the auditor report in detail. So in our view, such approach does not give the effect to legislative intent behind the 2015 amendment to the Act of 1996, which lifted the judicial scrutiny at a stage of 11 solely to the prima facie determination of the existence of the arbitration agreement. All I am saying, my lord, let arbitrator be appointed. If I do not have case, I will bear the expenses and will thrown out from the arbitration proceeding, and the award will be final. But how come, my lord, at this stage, my lord, my learned, without replying to my notice, without replying to my petition, without taking objection, my lord, regarding arbitration clause, he can argue a number of things, my lord. With deepest respect, I would request that let
what the question which
my lord,
presented before the court and we are required to decide it before allowing your petition,
my lord,
is what is that dispute to be decided before the arbitrator?
My lord, in notice
What is
itself,
that
I have said, my lord, in my arbitration notice, I have said I have suffered 3 crore 43 lakhs or 93 lakhs. My case is
so therefore
supported by documentary document.
Therefore, what we want to know,
my lord,
what we are asking you from
My
the
lord.
agreement, you show us that this because of inaction or wrong actions of the respondent,
Lord,
you are entitled to the claims in terms of the argument, in terms of the agreement,
my lord,
or the claims which are
I got what your lordship is asking from me. I got the point. My lord, my answer to the deepest respect is, if arbitration clause says, in case of any dispute, my lord, is it not a dispute? My lord, 2 lines cancellation of my contract after spending crores of
Mr. Counsel, we are not. You see, you cannot urge these questions before an arbitral tribunal like you do in a writ petition.
My lord, all I am
In a
saying,
writ petition, if it pleases the court, then court can grant you any order.
my lord, all I am saying, if there is arbitration clause,
You have entered into an agreement.
My lord,
Prima facie, this agreement appears, unfortunately, if I may say so,
My lord.
slightly one-sided. That there are no clauses for award of damages or compensation.
my lord,
Nothing is there.
There is a clause for the payment, but not the award, because my lord, every
Then-
agreement.
Now
does
the question is, even if we appoint an arbitrator, the
lord.
arbitrator has to decide the issue with reference to this agreement.
Yes, my lord. Yes, my lord. Yes.
Now, insofar as your other claims are concerned, that is barred in view of the judgment of the coordinate bench. In
My lord,
your
let the
earlier
arbitrator
petition.
decide it. My only submission is let the arbitrator decide this. I will reconcile my fate before the arbitrator if my
So therefore
claims are barred.
No, therefore, there are judgments of that mayor asking, all right, arbitral tribunal agreement is there, but is mayor asking sufficient to appoint an arbitrator
My lord,
and
not
relegate
mayor
parties
ask,
to an
my lord.
arbitrator?
My lord, it's not a dispute between two parties, my lord. Faith is involved here. We are dealing with the government of Assam. Upon the
You may be,
representation
but
of the government.
that has to be restricted to the agreement.
My lord,
The agreement,
may I suggest,
the
my lord?
agreement does not provide anything
My lord.
as to what happens in cases of termination, what happens
Yes,
in cases of
Lord.
shortcomings by the respondents. Nothing
No,
is there.
Lord.
How is the tribunal going to decide these issues?
The termination clause is not there, but renewal clause is there. It shows the intention, my lord, that this agreement was page 118, my lord, para 52, renewal clause. The renewal of the contract is subject to third-party departmental evaluation outcome of the satisfaction of the page 118, my lord, para 52.
Yes.
And then, my lord, notice period. My lord, renewal of the contract, evaluation of the third-party departmental evaluation outcome and satisfaction of the first. But the evaluation study report should be furnished 2 months prior to the closure of the contract period. So, my lord, and next, my lord, 53, notice period. In that event, second party desires to stop the supply the mill for any reason, it shall give 3 months notice to in advance in writing to the first party, failing which second party shall be liable to penalty as decided by the state government. So, my lord, notice clause is there. If there is a notice clause that I will intimate them, my lord, before conciliation, I deserve a notice. And so, my lord, whatever they have cancelled it, that is without notice, without asking, without any giving me any opportunity of hearing. So, this cancellation was arbitrary. All I am saying, my lord, let the arbitrator tribunal decide all these things, my lord.
No, this is exactly what we are asking you.
My lord, page 49
What is it to be decided by the arbitrator? Where does the arbitrator get a scope and the jurisdiction to decide these things if it is not mentioned in
with all
the...
due respect, my limited understanding is the arbitral tribunal will decide two things: whether cancellation without notice was proper or not on part of the respondent. That is one. If the notice cancellation was not proper, then whether I am entitled for any damage or not. If I am entitled for the damage, to what extent. Only three issues that arbitral tribunal, according to my limited knowledge and limited experience, the arbitral tribunal will decide. But my lord, appointment of arbitrator, my learned friend is so opposing this. I do not understand. He is very happy if I approach the civil court, because it will take another 20-25 years, my lord. I am a Delhi-based NGO fighting a case before your lordship in Assam. My lord, there is arbitrator, let the arbitrator be appointed. And my lord, Goki technology is very much clear after 2015, my lord. So far as the
Gopi technology does not even deal into this aspect of the matter.
my lord, I can
That is the whole difficulty.
There is a subsequent too many judgments on this aspect. 11-6, my lord. Too many judgments, but I will not bother your lordship on this. If your lordship will say, I will prepare a compilation and
please the judgments. We want to decide this issue.
my lord,
Please the judgment. We are asking you that only.
My lord, let the argument be concluded. I will file all those judgments before your lordship. My submission is, my lord, I am covered by the Goki technology. And regarding arbitration clause,
no, see,
a single line objection.
If you are referring to Goki technologies,
you
have to refer to the facts also.
Yes, my lord. The audit report was examined by the Honorable High Court of Bombay, and
Right.
the Supreme Court says no, at this stage, no.
Not only on those facts.
My lord.
The question which we are asking you is, in view of the arguments, in view of the clauses of the agreement,
My lord,
even if we refer it to the tribunal,
my lord,
more particularly in view of the findings by the coordinate bench earlier,
My lord.
what is the tribunal going to decide?
My lord, the
You
honorable
want the
coordinate bench had
legality-
not gone into the termination issue, my lord. By deepest respect, with deepest respect, my lord, kindly see para 6. Not a single whisper, not a single word regarding termination, arbitrary termination in the
No,
entire order, my lord.
No. Whether termination is legal, illegal, assuming it is, assuming the tribunal holds that it is illegal.
My lord.
But in view of the finding of the court that there cannot be specific performance now in view of the efflux of time.
I will not ask for a specific performance. I will only ask for damages which the honorable court say I may approach the civil court.
That's right.
But in the same
You
breath,
show us-
the honorable
you
court
show us
say,
any authorities that it is open to an arbitral tribunal to award that in arbitration.
my lord, subsequent judgment after the Goki terminology, I will file a compilation in 2 days. My lord, that only referral court, with all due respect, prima facie I view, my lord, that yes, there is a, and my lord, my star argument is not in the entire proceeding. The arbitration argument was never disputed by them. Never, not at all, not once, my lord. Not even filing of this counter affidavit. All they agree. And they said that the state government has power to appoint. My lord, the state government has power to appoint. Then Parkinson helps me. They can't appoint. Lord, my
No,
only
not on, we are with you.
My lord,
We are
my
with
lord.
you
I'm
that
so
the
deeply
respondents, officials, one person is holding dual charges. We are with you on that. We are only asking you, had the earlier order of the coordinate bench not been there, perhaps the tribunal could have decided many issues.
My lord.
But now the core issue
My lord.
of the court coming to a finding that you cannot press for specific performance in view of the efflux of time, and damages and compensation are left to be decided by the civil court.
My lord.
What is to be decided by the tribunal?
My lord, civil court.
Can assuming we appoint the tribunal and we permit the tribunal to look into including damages and compensation, will it not amount to review of that order, earlier order?
My lord, with deepest respect, my lord, this clause 6 is, my lord, do not bar me. It only says the civil court remedy can be there, but simultaneously arbitration was permitted to be invoked. My lord, civil court and arbitration had, my lord, equal direction, equal jurisdiction. My
Therefore,
lord,
now the question is,
my lord,
for a court under 11.6,
my lord,
is it only sufficient to look into the existence of an arbitration agreement and nothing else?
Prima facie, my lord.
Prima facie, we are convinced that yes, there is an arbitration clause.
Yes,
Question, we want to be even satisfied prima facie.
My
is
lord.
what is to be decided by the tribunal?
My lord,
What are the issues to be decided by the tribunal? Will it have any effect to refer the matter to a tribunal?
My lord.
Merely because there is an arbitration clause. What
My
is
lord,
the tribunal going to
my lord,
decide?
my lord, with deepest respect, according to me, I have a case. Because if the termination is illegal, my lord, I'm entitled for the damages. Quantum may be decided, by the civil court.
You support your arguments with the judgments.
My lord, within 2 days, 2 days time is required, my lord.
How much time?
2 days, my lord.
2 days. All
My
right.
lord.
Next again on, we'll have it on 12th of June.
12th of June, my lord, I am requesting, my lord, I will supply the judgments in advance. If your lordship consider that argument is concluded, then only my learned friend is there, Mr. Sancheti is
No.
there.
You have not even submitted supply the judgments. You will have to submit your arguments here.
To 12, my lord, 12. Yes, my lord, it's fine with me.
12th, all right.
No issue.
Placed on 12th. And the request made by the counsel to the petitioner for further arguments. Mr. P. Nayak appears for the response.
Yes.
That's all?
Yes.
SSA.
Sancheti is also there.
You are appearing for SSA.
That is the issue.
He's in dual service. Now, until now, I'm arguing on behalf of MDS. If it has also been filed by MDS.
We have issued notice,
No,
we
in the-
accepted.
No, Lordship has issued notice. Yes.
If the MDSSA feels that is not, or if you feel that no, there could be conflict of interest.
Nothing else. Lordship. I'm only going to ask for an authority from the same person. Lordship.
Do it.
As that I will do, Lord.
Do it. Otherwise, you are entitled to say that you represent only one and not both.
But this question will have some relevance, Lordship, in respect of the bars created under civil law. That is why I'm submitting repeatedly. Nothing else.
Yes.
Further, one more point, Lordship. Let my friends submit one judgment, Lordship, decided prior to appointment of an arbitrator. All these judgments are subsequent to appointment of arbitrator. So till the appointment of arbitrator is concerned, no judgment is there wherein the court has interfered.
Appointment of arbitrator means?
So whatever judgment my learned friend has submitted, Lordship, or cited, these are all
before appointment of arbitrator. Kindly see 3-page judgment. Bombay High Court refused.
We'll continue on 12th.
Bombay High Court says no, we will not appoint arbitrator. Honorable Apex Court had dealt with the Goki technology. We'll submit the entire bunch of judgments on 12th, my lord.
We'll examine that. We'll examine that.
I'm so deeply obliged. I'm so deeply.
Highly.
Yes.
Meet me, Lord. Lord, the petitioners before your lordships were the first batch of firefighting operators in the Numoligo refinery limited. Their appointment details I presented in a tabular form that your lordship can get in page 16 of the petition. The issues before your lordship is not a big one, but it may need some deliberations. The advertisement, when they participated, when they were appointed, the condition in the advertisement was, my lord, that your lordship can find it page 15, just previous page, serial number 2, below the table. Pay scale, perks and benefit, etc. would be similar as that is prevailing in the industry within the region. Meaning thereby, in oil industries, what is the pay, perks and pay scale, perks and other benefits will be similar with the other oil industries of the northeastern region. Plain understanding of this. It is the first batch of employment. Therefore, nobody knows what would be the proper scale and what would be the proper grade. These petitioners were appointed. Next page, you will also can see the page 16, my lord. Before that, my lord, due to reflex of time, this petitioner number 1, Devendra Sukya, he already retired. So for him, cause of action has been, as now there is no cause of action for this man. The remaining petitioners are there. Lordship may be pleased to strike out his name.
What is it? He's not even claiming notional.
My lord, our case is very plain and simple. We are not even claiming any financial benefit. We want, my lord, what is our prayer? That at the relevant point of time, the persons who were operating as a firefighters in different refineries of Assam, they were inducted in the service in the entry level. In IOC, it was 4. And in our, it was 3. We claim in IOC, my lord, firefighter grade, the starting grade of the firefighters and the receptionist are of same grade. Receptionist of that refinery. Ours, we are the HSL, higher secondary science pass candidates having driving license of professional driving license of heavy vehicles. We have been put below the rank of a receptionist. We are the skilled firefighters, and their role in a refinery is enormously important. It cannot be quantified, their role. in a refinery at least. But they have been kept below a receptionist. Therefore, my lord, these petitioners want that we do not want any arrear salary if it allows by this honorable court to accrue. We do not want financial benefit. We say, what is our prayer? That if grade is revised from the starting level, then we will be eligible to participate in a management cadre post in departmental examinations. Initially, the grades were up to grade 7.
Are these positions reflected in a set of rules?
They do not have any rules at all. They have some memorandum of understanding signed between the employees association and the management. They do not have any operating procedures or.
Your appointments were made pursuant to advertising.
Yes, yes. Selection process is not in challenge.
So for these posts to be advertised, there it must be sanctioned by the rule.
That is what, Mala, they don't have. They did not have and they don't have. That is the problem. But rules as such is not there. There are some MOUs. My friend will submit those MOUs and they have given first promotion. This point was when they were appointed in 1998-99. According to that MOUs, they should get the promotion in 4 years. But they have given the first promotion even before the confirmation. Immediately after their appointment, they have given one post, one grade promotion because the employees had a discussion with the management saying that we should have given in grade 6. Our claim is that we should be initial grade in the grade 6. Here the higher the grade, higher the post, higher the rank, sorry. In other services, grade 1 means higher, grade 4 means lower. Here the higher the grade, higher the rank. Now we prayed that you should start with our grade because we are skilled firefighters. You should start our grade with grade 6. Then perhaps we would have reached today grade 10. And we would have been eligible for participating in the managerial cadre post.
What is your grade otherwise?
Now, my lord, my friend has submitted given me a given me a table, my lord. Now I am in grade 8.
Grade 8.
8. Had it been started, my lord.
No, what was your starting grade?
In my case, it is grade 3. Now we have arrived in grade 8. See my appointment in 1998.
So you have come up 5 grades.
5 grades. And kindly see the persons who are below the category, below the rank, they have already reached the managerial post. In 2025, they have issued an advertisement, 17 February 2025. Just now I have received this copy, where they have said that from grade 8 onwards, we will be eligible for participating in the managerial cadre. But the marking pattern is that residency in the grade 8 and in between grade 8 and grade 10. If I am grade 10, then I will be getting more marks. If I am grade 8, then it will be lower. Therefore, if my starting grade.
What is your right? What is your the basis for making that claim?
What? Which claim? That grade 7?
It must start from grade 6.
Yes. The claim is this, that as per the advertisement, it says that it should be similar with the other oil industries. Page 15 below.
Yes.
Page 15, serial number 2, after the table, below the table.
Yes.
Pay scale, perks and benefits, etc. would be similar as that is prevailing in the industry within the region.
So in the other industry, what is the position?
In IOCL at that time, Milord, we have given some appointment letters of IOCL. At that time, IOCL had a, if I can take your lordship.
In the grade that you are inducted in, which is grade 3. your pay and perks would obviously be lower than the other grades, higher grades, say grade 4 or grade 5 or grade 6.
Of course. My lord, we have given up that also. Even if your lordship is pleased to allow and directs the refinery to NRL to revise our grades, there may be some amount of area salaries. We are given up.
There are no rules.
Yes, madam. There is orders, standing orders, which have been followed by the NRL. It's model standing orders under Industrial Standing Order Act. And in their their service is governed under the Industrial Tribunals Act, because they fall under the workman, the definition of workman.
Dispute.
Industrial dispute. We have specifically taken that plea in our affidavit in opposition that this grade, in fact, in their the MOU under which they have also annexed this MOU along with the which has been guidelines for promotion of this workman. They are governed under the Industrial Tribunal, Industrial Disputes Act, and their dispute has to be relegated to the Industrial Tribunal or the Labor Court. Now, page 44, if your lordship take, this is the first guidelines they have annexed. Second guideline, in fact, memorandum of understanding between management of Numaligarh Refinery Limited and Numaligarh Refinery Employees Union dated 12/1/2007 on guidelines for promotion of workmen. This is the second memorandum. And in the MOU between NRL and NREU signed on 11/8/2003, it was agreed by both the parties that workmen who have completed 4-year service, this is a word workman, have completed 4 years of service on the date of signing the MOU, that is 11/8/2003, will be promoted to the next higher grade subject to APAs having satisfactory level of performance. This dispensation was made without creating any precedent in any manner whatsoever. Now, first promotion, next page, page 45, my lord. First promotion for workmen who joined prior to 12/1/2007. So the first promotion will be in 4 years for all eligible employees who joined NRL prior to 12/1/2007. That is the date of signing of the above memorandum of understanding. In order to become eligible for promotion, the employee must have.
No. What we want to know is the claim which they're making. According to them, is it in conflict with any of the standing orders, MOU?
No, my lord. In fact, I have given this chart. All of them has promoted to grade 8. And now some of them are due for grade 9 also.
On that point, there is no quarrel. That they are giving the promotion in time. Sometimes it is delayed, but
your primary grievance that your grade
starting point.
Start from grade C.
Yes.
On what?
Had it been done in the
Have you brought comparison with the other industries?
Yes, that is what, if lordship can see.
I have accepted the appointment letter. If I may just take your lordship to page 20. This is the appointment letter of one of the petitioner. Page 23, last paragraph.
What else can they do but to accept the appointment letter?
I'm not in a bargaining position.
Now, my lord, if we take this, their prayer in the writ petition.
Page 23.
Page 23, last paragraph. If you are agreeable to the above terms and conditions, then please sign and return the duplicate of this letter by 29/8.
That is a standard clause.
My lord, they have accepted it.
They have
great.
No option but to accept. It's a job.
Yes, my lord.
Can they bargain that you bring us in this grade and that?
Kindly see the prayer. Kindly see the prayer made in the writ petition, page 11.
Yes.
to issue a writ in the nature of mandamus. In 2016, they are making this prayer to issue a writ in the nature of mandamus or any other appropriate writ or order or direction or like nature directing the respondents to put their petitioner's service in grade 6 at the entry level and to revise their grade from the date of entry to till present, considering the prevalent service conditions, and upon such revision of grade, they may be provided with all consequential benefits to which they are entitled. When they are making this prayer in 2016, they were appointed in 1998 in grade 3. And in the advertisement also, it is specifically mentioned this is a grade 3. And since all of them has got the promotion and due time, that nothing survives in this writ petition. They can always have.
When were you promoted last?
21.
21.
Then why are you agitating this now?
No, my lord, what my respectful submission would be, my lord. Now I am grade 8. We are grade 8 now. Now perhaps we are entitled to participate in the process of promotion from non-management group to management group. Management cadre grade 1. Now the question is, if just now I have given one document, that is advertisement of 17 February 2025. If Lordship can look into that document, my lord, kindly come to page 2, methodology. Has your Lordship got that document?
Advertisement.
Yes.
This is
Methodology for
17
selection.
17 February.
17 February 25. Next page, Lordship will get methodology for selection. Selection procedure of filling up the 10 position in JG01 of management cadre and for NM staff is proposed as below. The eligibility criteria shall be as proposed in paragraph 1 above. The selection process shall be comprising of the following: APA rating for last 5 years, maximum 15 marks, outstanding 3, very good 2, good 1. Seniority, residency in grade 8 to 10 combined, marks 20. 1 mark for every completed years up to the maximum 20 marks. So, my lord, if I stay in the grade 10 for a longer period, I'll be getting more marks than the grade 8.
No, we are asking you.
No, my lord, this has a bearings. If this is the standard of, if this advertisement, if these conditions remains for any future, I'm not claiming any past promotion. Or I want to a notional revision of my grade from the entry level, so that my grade as on today can be, if it reaches it cannot go beyond 10 because their grade is 10 only. Maximum grade is 10. It cannot go beyond 10.
No.
Even if Lordship allows this repetition, we cannot reach beyond 10 because 10 is the highest.
No, that is all right. Now, at this stage today, after you being promoted up to the grade 8 now,
Yes.
so you are holding grade 8.
Huh.
Now you are eligible to participate.
Yes, I'm eligible to participate, but this condition criteria of the selection that I'm just I have read before your Lordship, this will give a more dividend to a person who is already in grade 10.
No, that grade 10 or grade 8, grade 8, whatever it may be. This 8, you are referring to this 8 to 10 combined, na?
Huh.
20 marks.
20 marks,
for
yes.
each complete-
Second clause.
So you want to say that had you been, how many years of service have you put in? Till now, how many years of service?
From 1989, Milo. 98, sorry, from 1998.
88,
98, from 1998.
98.
27 years, Milo.
Huh?
27 years. 2 years till 2025, 20. 2 years till 2020. Now 25, 26 years, plus minus 26 years.
So you want to say that
Parity is not maintaining. That is why this hard burning.
now in grade 8, how many years have you put in?
My lord, I was given
2021.
2021.
21. So in 21, you will get about 3 marks. from 21 if it is counted, till
For one completed years,
Uh,
1 month.
3 years, three marks.
For 3 years, 3 months.
Three. But if you had been in grade 8 initially.
Grade 6 initially.
No. You want to come in grade 8, isn't it? Your grievance in the writ petition is that instead of appointing us in grade 6, make us entry level at grade 8.
No.
That's what you say.
I said they made us in grade 3. I said that it should be grade 6.
Okay, grade 6. All right. Grade 6. So from grade 6.
From grade 3 to grade 8, it took to more than 20 years. That is the difficulty. And persons who are below us, having below lower qualifications, and the firefighters in a refinery are Milord, the frontliner.
But where have you shown that parity has not been maintained?
My lord, vis-a-vis the advertisement, if your lordship can come to
So advertisement is all right. Advertisement they say the industry standard. Advertisement says industry standard.
If a lordship can come to one affidavit that I filed, my lord, on 31/2/17. By Devendra Sakya. 31/2/17.
Yeah.
In page 4 of that affidavit, an affidavit in reply.
3-2.
Sorry, 3-2. I'm sorry. I'm so sorry. 3/2/17. Page 4 of that affidavit. Paragraph 7. This table, this is a comparative table of the relevant time, post and designation in NRL and IOC. Qualification required NRL and IOC, grade offered at entry level NRL and IOC. In NRL, fireman 3, which is in IOC, the post is named as firefighting operator D. In NRL, qualification is higher secondary science plus HMB driving license. In IOC, HSLC plus HMB driving license. NRL grade 3, IOC grade 4. Here itself one grade is below. In NRL, there is another post, clerk and typist. In IOC, it is called receptionist plus clerk typist. Required qualification, higher secondary with diploma in typewriting. In NRL, in IOC, graduate with diploma in typewriting. In NRL.
So you're saying that in respect of other posts, more or less parity is maintained.
Maintained.
Except firemen.
Except the firemen. Whereas they are the frontline warriors to protect the industry.
Well, if the fireman comes, that doesn't come within the definition of this clerk and typist.
Understand
Not
that
clerk
that
and
may be
typist.
that may
It is not there.
They are.
Their claim is that you say industry standards will be maintained. You have maintained industry standards in respect of receptionist, typist, clerk.
No, my lord, that doesn't come within the purview of workmen.
Huh?
Typist, the process operator, they doesn't come within the purview of the definition of workmen under the Industrial Tribunal Act. But they are, firemen are the workmen under within the definition.
That's right. If you come to page number 88, page 4 of the reply available, their grievance is that if there's a comparison made between NRL and IOC,
yes,
fireman in NRL is getting grade 3, whereas fireman in firefighting operator or fireman in IOC is getting grade
D.
No. You see the grades on the right hand side.
Yes, grade 4.
So NRL is grade 3, IOC is grade. So they say that industry.
Well, that is without any supporting documents. I don't know.
No, we have filed annexed documents. I cannot say this on oath without a document. These are here, my lord. In the writ petition itself, it is there.
Right. We will continue next week. Next week.
Lordship, hardened part.
give us some material to say that, otherwise, is there?
My lord, kindly come to page 54 as well, just.
What is the, IOC is a shareholder?
No, 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 no. I was not a shareholder, but of the same industry, my lord, oil industry.
54.
Page 54. This is the letter, appointment letter of receptionist in grade 4, 1991. Relevant time, relevant post of same oil industry, similar industry. Then, my lord, prior to that, if lordship can come, page 52.
Is there any set of standard, what you call standing orders or
Yes,
other
yes, my lord.
rules?
There is a standing orders under Industrial Standing Order Act.
No, for oil workers?
No, there is no.
Difficulty is that only.
For-
They don't have any set of rules. Neither he can argue nor can I. The only thing that MOU. That is the difficulty.
MOU has been three numbers of MOU has been entered with the workers as well as with the help of the labor officers and the management of the this NRL. So this MOU governs the promotion of these workers.
And that is also not elaborate. These MOUs are also not elaborate.
They are participant in this MOU.
Maybe, but we are just discussing of the merit of the
They have
whole
to
thing.
challenge that MOU.
That's a different thing. We are not on discussing the merit of the case. We are just saying that in an academic side, my lord, that these are not elaborate.
They have an alternative remedy of going to the industry tribunal.
No, that is after admission by on the first day itself it was admitted. That argument is not holding the field.
Still there or not?
No, after admission, how can it be, my lord?
I heard counsel to the party. It's next page. So we'll keep it on 12. 12.
But 12th, I have a different matter. Can I be on 13?
17.
17, yes, yes.
17, hard in part.